right, we will go ahead and get started. Good morning and welcome everyone to TSCA Reform 5 years later. My name is Chandler Randall and I'm the Manager of Educational Programs here at the Environmental Law Institute. And we are so delighted to welcome everyone to this ELI, Bergeson and Campbell and the George Washington University Milken Institute School of Public Health co-sponsored conference. I'd like to start today by thanking Lynn Bergeson, all the incredible folks at Bergeson and Campbell, Dr. Lynn Goldman and Bob Sussman for working diligently to develop today's programming. I would also like to thank our outstanding speakers, moderators, and panelists for joining us today to lend their expertise to today's program. The full speaker and panelist bios are posted on ELI's website at www.eli.org, and I would encourage you to check out their experience in more detail there. As we begin, I have the privilege of introducing Dr. Lynn Goldman. Dr. Goldman, a pediatrician and an epidemiologist, is the Michael and Lori Milken Dean and Professor of Environmental and Occupational Health at the Milken Institute School of Public Health at the George Washington University. Formerly the Assistant Administrator for Toxic Substances at the U.S. Environmental Protection Agency, where she oversaw the Office of Chemical Safety and Pollution Prevention, she is a renowned expert in pediatric environmental health and chemicals and pesticides policy. She has engaged in translating research to policy through writing policy analyses and via congressional testimony in service of successful efforts by Congress to achieve the passage of reforms to the 1996 Food Quality Protection Act and the 2016 Lautenberg Chemical Safety Act for the 21st century. Thank you so much, Dr. Goldman. And with that, I will turn things over to you. Thank you.
Thank you so much. It is my pleasure to welcome you all to this conference. I know you're very busy, and I'm delighted that you're taking time to join us to discuss this timely and important topic. I want to personally thank the Environmental Law Institute for taking the lead on putting this together, along with the law firm Bergeson and Campbell.
I'm going to tell you can hardly hear.
I know that this takes a lot of time to organize, and particularly thanks to Chandler Randall, Caitlin McCarthy, and many others, but also Bob Sussman and Lynn Bergeson for their personal attention to putting this agenda together. This is a time of great uncertainty and anticipation when it comes to the Toxic Substances Control Act. When I look at the list of the attendees, many of you who worked so hard to get chemical reform passed into law in 2016, I recognize that there is a great deal of interest in this topic today. Some of you who have been involved for some time recognize that the Frank-Lautenberg Chemical Safety Act of the 21st century, or TSCA reform, was remarkable in many ways. It was the first time in 40 years that the nation's chemical safety system had been overhauled since 1976. And importantly, the bill had very strong bipartisan leadership and support. And you know, that happens often these days in Washington. I personally had testified before Congress and worked with many colleagues to voice my support for this landmark chemical safety reform law. Annually, since that historic legislation was signed into law, with the exception of 2020, we have co-sponsored this event. But it is sobering to mark the 5th anniversary, a time when many of us, including me, would have predicted there would have been far more progress. To say that implementation has been bumpy would be an understatement. But I'm not going to review the details around implementation. I think you'll hear them in the course of today's conference. But I will focus on why the Lautenberg Act happened in the first place and what brought legislators, industry, environmentalists, public health advocates, and even state attorneys general together to reform the law. From many perspectives, it was clear that the old TSCA was ineffective. It had allowed tens of thousands of chemicals to be grandfathered into commerce with no assurance of safety, while also allowing new chemicals on the market every year without demonstrating that they were safe either. The 1976 law left EPA nearly powerless to regulate even chemicals that we knew were toxic, as was abundantly clear when EPA was unable to phase out most uses of asbestos. Not only the general public, but also state governments and health and environmental experts were often kept in the dark because of the inability of EPA to share even the most basic information about chemicals with the public. But the Lautenberg Act completely overhauled TSCA. The amendments are very numerous, and I'm not going to describe them in detail, but the most significant had to do with EPA's ability to collect information, to review new chemicals, and to prioritize and manage existing chemicals, as well as major changes to how EPA handles information. These provisions were with a purpose of serving a number of important policy objectives. One, of course, to enable EPA to protect the public's health and the environment from toxic chemicals, the basic mission of the agency. Particularly in a number of ways, it directed EPA to prioritize the most hazardous and persistent chemicals and those that threaten the health of those who are most vulnerable, especially infants, pregnant women, and others who are more vulnerable. It also directed EPA to protect the most vulnerable ecosystems, the most vulnerable environments. Thereby, of course, a major goal was to increase the confidence of the public and the business community that chemicals and commerce in the EPA, that as permitted by the EPA in the United States, are safe. That confidence in the system is core to having a smoothly and functioning industry, and to strengthen federal chemical management even while working in partnership with states. And of course, at the end of the day, to provide clarity and predictability with regard to how and when EPA will make decisions about chemicals, something that I sense that many in this conference today are hoping for. As many in this conference today predicted when the law was signed, implementation over the past 5 years has been difficult. There were many statutory deadlines. These deadlines were met. However, EPA, in my view, did not use the opportunity of the statute to transform how it makes decisions. Rather, I think the Trump EPA attempted to maintain the status quo or slow implementation of the law whenever possible. In consequence, it's hard to point to very many achievements in terms of environmental and public health protection. In a minute, I'm going to introduce the person who is now responsible for implementation of TSCA in the Biden administration. In so doing, I have been reflecting on 1993 when I joined the EPA as Assistant Administrator for Toxic Substances in a similar position. I had come 5 years after Congress had enacted a bill called FIFRA 88, which was a major reform of how pesticides are controlled in this country. This was a process called re-registration. When I joined the EPA in 1993, the EPA was not making progress toward re-registration of pesticides. It hadn't met its own deadlines, and even worse, it was not focusing on the pesticides of most risk. So the pesticides that had been re-registered were not the riskiest ones. I was faced with a dizzying array of expectations by all the stakeholders centered around the hundreds of pesticides that were involved in this law. Yet by 2008, as required by the statute, the re-registration of the older pesticides was completed. My experience with EPA having been able to put re-registration back on track gives me confidence that EPA can do that again when it comes to TSCA. In many ways, since the Lautenberg Act was passed, EPA is continuing to be in a transitional phase. And what do I mean by that? I don't think EPA yet has the staffing. I don't think it has the systems. I don't think it has the information that it needs in order to implement the statute. Additionally, EPA continues to be caught up in a number of legal battles about how the bill has been implemented. Some of these have already been judged against the EPA, causing them to go back and do work over. Others are still in process. I think it is fair to say that the last administration was extremely unfriendly to environmental regulation and did not seek to build consensus on how it implemented the law. I think it's possible also that some people on the other side now feel it's their turn to just call the shots. However, EPA needs to work with all of the stakeholders to get this train back on track. That in itself is going to be a major effort for this administration. I don't need to tell all of you that none of this makes any sense at all in terms of protecting public health and the environment. We need to continue to make steady progress on regulating chemicals both today and in the future. And EPA's job is a daunting one. Even in the best of conditions, there's a cascading series of complex decisions, expectations to be managed, as well as new risks that are going to emerge that we can't even predict today that are going to become an issue for the Biden EPA. To date, while there have been very few wins for public health, it's also true there's been very little assurance to the public or the industry that the chemicals on the market in the US today are safe. But we do have a law that can make that so. And I have confidence that the Biden EPA will find ways to achieve that. How will that happen? I can't tell you. I think that is something of interest to all of us today. Whether you're here because you're passionate about protection of health or the environment, or you just want to be able to predict where things are going, I think we're going to have a very interesting conference today, and I look forward to a robust discussion. Thank you so much. I think it is now my pleasure to introduce our first speaker. Please, somebody give me a heads up if that's not the case. I also want to just point to a couple of things around the actual format that we're using. It is possible for you to put things in the chat window, such as if you're having problems with the audio, which a couple of you have chatted about, as well as any other messages. I am told in the chat that we are waiting for Dr. Friedhoff to arrive. And are we a little bit ahead of schedule? It's okay to tell me if so. Yes, we are. Do we want to pause to see if there are any questions for me as we're waiting for Dr. Friedhoff to arrive? I'm certainly monitoring the chat window if so. A question, would consensus not require raising public awareness? That's a really good question. I think actually the enactment of the bill required that. And when you think about what was going on 5 years ago, there was a lot of discussion about toxic chemicals, and in particular, some specific ones. There was a lot of activity also at that time in the states with legislation that states were enacting specific to individual chemicals, which I think we're seeing that kind of surge of activity again, and that it's an inevitable result of the lack of progress. Is connecting the substances to the environment. Okay, so how do you make the connection, I guess, is I'm going to rephrase one of the questions, between the chemicals in the environment and diseases. And we do that in a number of ways. I think significantly, we can often trace the chemicals and find out if they're actually entering our bodies, where they are in the environment, what the environmental levels are, where they're accumulating. We have data that we can generate in laboratories, whether data from testing animals, which we try to avoid today, or data about how these chemicals interact with our cells, with the molecules in our body. We have some cases where we actually have epidemiology studies that show links between various chemicals and health outcomes. But it's a very huge area, not something that we'll be talking about a lot today, but it's a very important piece of the EPA's work to be able to make those linkages. Question whether TSCA implementation is more challenging because of the hyperpartisan world in which we live. And I would say yes, that does make it very challenging, although we have still in the Senate and House of Representatives a number of people who are elected representatives of the public who are involved with the enactment of the legislation and who understand TSCA and continue to support it. And that should be extremely helpful to the EPA. However, the way that the law was implemented over the last 5 years does make things difficult because there hasn't been the kind of collaboration engendered by the EPA among stakeholders, the discussions that are needed to work things through. And when you have had an administration that has tended to act unilaterally, which I believe was the case of the last one, that is going to create a challenge in terms of rebuilding that. And speaking of which, I see now on screen the person who is charged with the responsibility for doing that and our next speaker, and I'm going to introduce her. Welcome to our conference, Mikkel Alana Friedhoff. Dr. Friedhoff, our keynote speaker. As you all know, she is now the EPA Assistant Administrator for the Office of Chemical Safety and Pollution Prevention, recently confirmed that position by the US Senate. Prior to being sworn in as Assistant Administrator, she joined the EPA as the Principal Deputy Assistant Administrator in January of 2021. She has had a remarkable career, one that I would say nearly perfectly equips her for the daunting challenges that she faces as Assistant Administrator. Dr. Friedhoff has more than 20 years of government experience, most recently as the Minority Director for Oversight for the Senate Environment and Public Works Committee. She began her congressional service in 1996 and then Congressman Ed Markey's office as Congressional Science and Engineering Fellow after receiving a PhD in physical chemistry at the University of Rochester. She has served on the staffs of the House Science Committee, the House Select Committee on Energy Independence and Global Warming, the House Energy and Commerce Committee, and the House Natural Resources Committee. With environmental expertise spanning this impressive range of policy areas, Dr. Friedhoff's legislative work includes the 2016 reauthorization of TSCA, the 2019 legislation to address polyfluorinated compound contamination, the fuel economy provisions in the 2007 Energy Independence and Security Act, and a law requiring the creation of an online database of potential consumer product safety defects. Given Dr. Friedhoff's presence in the room during Lautenberg's development and subsequent enactment, she is uniquely well qualified to offer remarks this morning on TSCA reform 5 years later. I should say I personally am envious of her for her background in chemical engineering, in physical chemistry, as well as in Congress, because I think that she is ready to run from day one. And I think that that is what we're going to need. And I think we're going to hear that from her. So thank you so much, Dr. Friedhoff. It's a pleasure to have you with us. I'm now going to turn the program over to you.
Thanks so much, Lynn, for that wonderful introduction. Just making sure everyone can hear me.
We do.
Okay, great. I have a new computer, so this is its first time through Zoom. Well, thank you so much. I'm happy to say that this is actually my 4th ELI TSCA conference, and it's truly an honor to be here with you today. This event has always been energizing and enlightening, and it's actually become an annual gathering place for many of us working on TSCA. And it's also an opportunity for those of us at EPA to hear from you. The information and the ideas we get from these sorts of meetings help us understand the needs of stakeholders and really gives us a chance to hear your thoughts about our work to implement TSCA. So just over a week ago, we celebrated the 5th anniversary of the signing of the Lautenberg Act. And the hope for this still relatively new law is that it will stand alongside other key environmental statutes like the Clean Air Act, the Clean Water Act, and the Safe Drinking Water Act. These bedrock environmental laws have made a positive impact in people's lives and give EPA the legal authority to pursue our mission of protecting human health and the environment. But there's still more work to do in order to realize the promise of new TSCA. As I'm sure you all know, before TSCA was passed in 1976, the US government had few records of what chemicals were imported, manufactured, used, or released into the environment. There was no way to regulate or even assess chemicals for health and safety or environmental impact before they came to market. And the original TSCA change currently in use, and any new chemicals coming to market. The basic premise of the original statute was that it gave EPA the discretionary authority to protect Americans against unreasonable risks presented by chemicals already in the marketplace. As we all know, the original law didn't work quite as intended. Soon after TSCA was implemented, the TSCA inventory showed that there were some 62,000 chemicals on the market, which were all grandfathered into the law and didn't require any additional review. And after being in place for 40 years, only a handful of the chemicals had been assessed and regulated. It wasn't that EPA wasn't working hard. It's just that the original TSCA didn't have the teeth to allow, let alone require, EPA to take more than basic steps to regulate existing chemicals. Under the old law, EPA wasn't even able to enact a ban on asbestos, a known carcinogen that kills thousands of Americans every year. A federal court shut down EPA's ban on asbestos in 1991, ruling that the record didn't support a finding that EPA's regulation was the least burdensome, the law's standard applicable to risk management rules at the time, and vacated the affected portions of the rule. And that decision significantly harmed EPA's existing chemicals efforts thereafter. Despite growing calls for reform, TSCA remained unchanged for decades. And in the meantime, as more uses for more chemicals evolved, so did our collective understanding of the potential environmental and health impacts that some chemicals have. And over time, a broad coalition united around the need to update TSCA. As a Hill staffer, I had a front row seat for TSCA reform. There was real excitement and the occasional late night adult beverage in the rooms where it happened, which usually were in Senator Udall's conference space. And those of us who were fortunate to shape the new law felt the weight of the expectations and the hopes that we get it right. So when that moment came 5 years ago, when the Lautenberg Act was signed into law, there was just a rush of excitement and gratitude. And I know that many of you felt the same way in that very moment because you were also there in the room where President Obama signed it into law. New TSCA gave EPA the authority and the responsibility to truly protect American families and workers from exposure to dangerous chemicals. It removed the discretionary authority for taking action on existing chemicals and replaced it with an ongoing responsibility for EPA to assess and address the unreasonable risks the agency found. With new authorities now law, the energy around TSCA turned to implementation. The agency had to develop new rules and develop policies and procedures to undertake the broad sweeping changes now required for both the new and existing chemicals programs. Since its passage, EPA identified, scoped, drafted, peer-reviewed, solicited public input, and ultimately issued the risk evaluations for the first 10 existing chemicals to undergo review. The next step in the process, risk management, has also begun for some of these chemicals. The agency has used its new authorities to require companies to develop and submit data needed to inform risk evaluations. EPA issued risk management rules for 5 persistent, bioaccumulative, and toxic chemicals as required by TSCA. Amended TSCA also included requirements for EPA to make affirmative determinations on new chemicals before they are allowed to enter the market. And EPA has increased the amount of information made publicly available online on new chemicals and has taken strides to ensure the information companies claim as confidential business information is appropriately substantiated as required in TSCA. This is just a snapshot of the work that has already taken place to implement the Lautenberg Act, and I am so grateful to EPA's fantastic career staff for all their hard work. Despite these advancements, many actions taken under the last administration left EPA with an internal and external trust deficit. Which affected our ability to carry out our core duties and function to protect health and the environment. It was also clear that some of EPA's actions during this time were inappropriately driven by the previous political leadership rather than sound science. Courts have thrown out some of the agency's decisions, and other decisions still face legal challenges. We're taking steps to restore trust and revise some of the past policy decisions that undermined it. So as I've said a number of times in the past months, President Biden asked us to re-examine many of the decisions that were made by the previous administration. And while I've spoken generally about these policy shifts, we have yet to describe what those shifts will actually mean for each of the first 10 chemicals evaluated under TSCA. Today, I'm happy to say that we're ready to be more specific about how the agency intends to move forward. I frequently use the word surgical to describe our potential supplementation of the first 10 risk evaluations. This is because there's no doubt that unreasonable risk was found for most uses of all of those first 10 chemicals. And this is also because our goal must be to move expeditiously forward on risk management to ensure that all populations that may be exposed to the chemicals are protected from those unreasonable risk. And of course, we also need to ensure that all of our actions are strongly supported by science and the law. We have some planned changes to our approach that will impact the risk determinations for all 10 chemicals, changes that will impact only some, and changes that may only impact one of the first 10. Let's start with the planned changes that will impact all 10. Under the previous administration, EPA made separate unreasonable risk determinations for every condition of use of the chemical. Now, of course, Congress intended for EPA to assess and analyze each condition of use the agency identified, and our risk evaluations will continue to describe and assess the specific exposure scenarios for each condition of use. However, for the first 10 chemicals, we intend to make a single unreasonable risk determination on the whole chemical following an evaluation of all conditions of use. Let's take methylene chloride as an example. EPA found unreasonable risk for almost every one of the dozens of uses of the chemical. It simply makes no sense to write the same thing down dozens of times. We'll do the analysis for each use, but plan to make the determination of unreasonable risk just once for the whole substance. Putting this approach into practice, EPA intends to withdraw the previously issued orders for those conditions of use for which no unreasonable risk was found. And we intend to then issue revised unreasonable risk determinations for these chemicals as a whole substance and seek public comment on this approach. We'll continue to show our work. We'll continue to describe the hazards, exposures, conditions of use, and potentially exposed or susceptible subpopulations we consider. But for the first 10 chemicals, and for any similar chemical that presents significant risks across many uses, we believe that a single risk determination rather than dozens is more appropriate. To be clear though, this intended action would apply to all 10 of the first risk evaluations, but this policy shift would not require the agency to change any of its underlying analyses in the risk evaluations themselves. Another change we intend to make for chemicals undergoing risk evaluation is the assumption made around the use of personal protective equipment, or PPE, in the final risk determinations. In the final risk evaluations for the first 10 chemicals, the last administration generally assumed that workers were provided and used PPE appropriately. OSHA's data on violations of PPE use suggests that assumptions that PPE is always provided to workers and always worn properly are not justified. For example, respirator safety violations are always high up on OSHA's annual list of the top 10 most frequent types of violations. If the agency continues to assume PPE usage, our risk evaluations could underestimate the risk, And in turn, the rules we're developing to protect workers might not actually provide the needed protections. EPA is therefore revisiting the assumption that PPE is always used in occupational settings when making risk determinations for a chemical. And instead, we plan to consider information on the use of PPE or other ways industry protects its workers as a potential way to address unreasonable risk during the risk management process. I should note that we know many companies are compliant with and even go beyond what OSHA requires to keep their employees safe. We don't want to invent new occupational safety requirements if existing practices are working. So we very much welcome input on what works and what doesn't work from companies, workers, and anyone else who has information we could use as we move forward with this approach. All of the first 10 risk evaluations already include exposure analysis with and without PPE. And thus, removing this assumption doesn't create a need for new analysis. And the shift can be folded into the single whole substance risk determination we intend to make. What this does mean is that for the previously published risk evaluations, it could change some of the conditions of use for 6 of the first 10 chemicals for which no unreasonable risk findings were made based on the use of PPE. So specifically, this could impact 5 conditions of use of methylene chloride, 7 conditions of use of 1BP, 4 conditions of use of HBCD, 3 conditions of use of NMP, 1 condition of use of perchloroethylene, and 2 conditions of use of dioxane. A second change that we believe could impact the regulation of a subset of the first 10 chemicals addresses the previous administration's choice not to assess air and water exposure to the general population because these exposure pathways were already regulated or theoretically could be regulated under another EPA administered statute like the Clean Air Act, Safe Drinking Water Act, or Clean Water Act. For example, in the original risk evaluation for 1,4-dioxane and in a supplemental assessment, EPA did not evaluate certain exposure pathways, including ambient air and drinking water for the general population or populations that could be considered potentially exposed or susceptible subpopulations. 1,4-dioxane is also generated as a byproduct in some manufacturing, industrial, commercial, and consumer uses. But EPA's assessments of conditions of use as a byproduct were only conducted for some consumer products and use scenarios. This approach has left significant gaps in the potential exposure to the general population and workers. EPA intends to reopen and update the dioxane risk evaluation to consider whether to include these additional exposure pathways and additional conditions of use. These pathways will likely include exposure from drinking water sources and may also include exposures from ambient air. EPA also intends to assess occupational exposures to products and uses where 1,4-dioxane is generated as a byproduct that were excluded from the 2020 supplemental and final risk evaluations. Because we're reopening and updating the dioxane risk evaluation, we plan to allow for public comment on changes we may make before finalizing it. The approach to exclude certain exposure pathways like ambient air and drinking water also resulted in a failure to consistently and comprehensively address potential exposures to potentially exposed or susceptible subpopulations, namely fence-line communities. These are communities where residents live in close proximity to industrial facilities, where chemicals are used and where releases to water or air could happen more frequently. For 6 of the first 10 chemicals, we believe that we need to be certain that the policy decision to exclude these exposure pathways will not lead to a failure to identify and protect fence-line communities. These 6 chemicals are methylene chloride, trichloroethylene, carbon tetrachloride, perchloroethylene, NMP, and 1-bromopropane. To determine if these 6 chemicals present unreasonable risk to these communities, EPA is developing a screening level approach to conduct ambient air and surface water fence line assessments. The screening level approach will use existing data and information to determine if there is the potential of unreasonable risk to fence line communities associated with air and water exposures. We plan to work across the agency to make sure the approach is consistent with methods used in our sister offices like the air and water offices. And EPA plans to use that information to update its approaches and methods, and then use it for all 6 chemicals, as well as future risk evaluations. If our screening level approach yields information that there's no unreasonable risk in these communities, we intend to move forward to propose risk management rulemaking, knowing that we've not left communities vulnerable to exposures to these chemicals. Alternatively, if we find through the application of the screening level approach that there may be unreasonable risk to these communities from a chemical that cannot be addressed without supplementing the risk evaluation or through the risk management approaches the agency is already considering, the agency will conduct a more comprehensive exposure assessment of fence line communities for that chemical. Late this calendar year, we plan to make these approaches and methods and their application to 1 or more chemicals available for public comment, and to have them peer-reviewed by the Scientific Advisory Committee on Chemicals, or SAC. EPA plans to hold a peer review meeting early next year to hear from the SAC, and then we'll update the methods based on the peer review's findings as well as public comments. We should know whether we will need to formally supplement these risk evaluations by early next spring. If additional analysis is required for any of them, that would take about 6 more months. In parallel with these efforts, our risk managers are continuing to move forward on the development of proposed rules for these 6. And upon the completion of each risk evaluation, we'll also be prepared to quickly publish proposed risk management rules for public comment. So I've said we currently believe we will likely need to supplement the dioxin risk evaluation before proposing a risk management rule. And I also should add that I believe that rule may well be the last of the first 10 substances to be finalized. I've also said that we're still determining whether we need to revise the risk evaluations for 6 other chemicals to identify and address potential fence line community exposures, while we simultaneously consider and work on potential rulemaking actions for those substances. And that leaves 3 of the first 10 chemicals that I've not mentioned. For 3 chemicals that have undergone risk evaluation, HBCD, PV29, and asbestos part 1, we currently believe that the risk evaluations are likely sufficient to inform the risk management approaches being considered, and that these approaches will be protective. Moving forward, we intend to soon reissue the risk determinations that amend the approach to PPE and include a whole risk determination for these, a whole chemical risk determination for these 3 substances. The teams are also working expeditiously on risk management, and we believe that the proposed rules for these 3 substances will likely be the first of the 10 to be ready for release. We're also well underway with scoping and evaluation of asbestos part 2, which includes legacy uses and associated disposal for chrysotile and all conditions of use for other fiber types. What I've discussed here is our approach to ultimately finalizing the first 10 risk evaluations. I feel very strongly that this is the best approach to balance the competing goals, quickly managing the risks of these chemicals while fulfilling the obligations of this administration and TSCA, both of which will set us on the right trajectory to have a sustainable existing chemicals program. The changes I outlined today demonstrate the vitality of amended TSCA and why the law's 5th anniversary is really still cause for celebration. TSCA is still a pretty young law, and we're just getting started. And as we move ahead, your continued input and engagement will be essential. When we work together, our work is more comprehensively protective of human health and the environment, more reflective of real-world scenarios, more useful, and most importantly, more worthy of the public's trust. In closing, I want to thank you again for inviting me to speak today. I think we have some time for questions, and I look forward to hearing from you. Thank you again.
And thank you so much for that. I think that that was a wonderful overview, and I'm looking in the chat window for questions, but I think that maybe I will ask the first question. And I'm very aware of how important it is in a role like your role to be able to bring the stakeholders together when it comes to the decisions that you make. And especially when it comes to toxic chemicals, that is a very complicated job because your stakeholders include not only the industry that manufactures the chemicals, not only the public health and medical community, environmentalists, but also consumers, workers, basically everybody. And you've come into this job at a time where there hasn't been strong engagement by EPA.
I'm so sorry, Lynn. I'm having real trouble hearing you.
Okay, is this better?
Yes, thank you.
Okay, you've come into the job at a time when there has not been strong engagement by the EPA of all of the stakeholder community. And in fact, where there perhaps has been, preferential access by some and many others who felt that they haven't had much access at all to the decision-making process. How are you going about the job of, if you may, holding the listening tour, being able to engage across the multitude of communities who care about chemical safety and the implementation of the law?
Thanks very much for that question, because I mean that, one of the hallmarks when we were writing the law of the way the staff that were working on it engaged was that we really did meet with everyone. We really did talk to everyone. And I think the result benefited from that engagement. I've actually heard complaints from all sets of stakeholders, not just one set, about the degree to which a normal technical back and forth happened or didn't happen in the last few years. And, I've had multiple meetings with environmental stakeholders, multiple meetings with industrial stakeholders, multiple meetings with labor organizations and other public interest groups. And I hope, and I've also asked my staff to do the same thing. I think everything we do will be more durable, more robust, and will benefit from hearing all perspectives as we're moving forward with making these decisions.
Thank you for that. I'm going to go to another question that's in our chat window. And I think it's very interesting when you deal with chemical regulation, unlike so much of what EPA does, that chemicals not only have an impact in local communities, in areas, around chemical manufacturing, around the use of and commerce in the chemicals, but also at state, at national, and even global levels. And especially given the fact that, some chemicals are very persistent, and what we do actually has an impact on the entire planet, not just on the local area where the chemical might be manufactured or used. And the question really is about not only how our regulatory system, compares with other systems, but also how EPA will work in cooperation with other countries when it comes to the regulation of chemicals.
So, our law, we obviously clearly primarily need to follow our laws. Our law requires us to take a risk-based approach, whereas some other countries' laws look more closely at hazard. But our international engagement activities are pretty strong, and we regularly try to work collegially with other countries in their and in understanding their regulatory approaches and in developing a common understanding of the scientific underpinnings of our regulations. You're muted, Lynn, I think.
So I am. Thank you. So there's a question in the box about and I'm going to make it a broader question, the expertise that you find that you have there in the chemicals office. And the specific question has to do with industrial hygiene, the fact that worker protection, worker exposures are driving some of the risk evaluations. But I'd like to hear from you more broadly about, do you feel you have the scientific expertise that you need in the office? And what kind of efforts are underway to strengthen the science in the office?
Thanks very much for that question. I appreciate it. First of all, I can't say enough about the career staff at EPA. They're wonderful, they're talented, they're dedicated. but they are also under a great deal of stress. I think, when you think about it, the new law gave EPA a great deal more responsibility. And when you look at the annual budget requests for the past few years, those requests don't reflect the new responsibility that Congress gave the agency. And so I do think we've been under-resourced and understaffed. And I think that that's something that we're really very much hoping we can continue to work on in the coming years. That said, I know that our staff is engaging with a wide range of stakeholders, and as well with our sister agencies that have more expertise in the worker protection space. And so I do feel like we're going to be on very solid footing when it comes to getting these rules out.
As another question, and I think this actually ties also to science capacity, to be honest, but specifically a question about the requirement in TSCA to report to Congress.
I'm sorry, I'm not hearing you again. I'm sorry.
Okay, and I'm not muted now, so that's it. Yeah. The requirement to report to Congress on your progress in reducing animal use in chemical testing, which is, I preface that question with, this is another issue that also requires a lot of science expertise. Obviously, replacement of tests, development of new tests is an extremely complex issue. But has EPA met this deadline, I guess is the question, and whether you have any comment about that.
So you're referring to, I think that the deadline that the former administrator set for eliminating animal testing, is that the deadline you're talking about?
Well, according to the questioner, your EPA is required to report to Congress on progress in reducing.
Oh, I see. Okay, I know. Yes. So
Yeah.
I think that report is in the various in a review stage right now, and I imagine it will get to Congress in the near term if it hasn't been sent already. But I also think some of the animal testing replacement briefings that I've received have been really very exciting. I think the work, it's not just OCSVP, it's also the research, the Office of Research and Development at EPA. They have really made amazing progress in reducing the use of animals for testing and developing methods that in some cases are even better than animal testing at predicting impacts to humans. So it's, of course, we're not going to be replacing all animal testing tomorrow, because there's still much more work to be done, but I think the progress is really exciting.
As another question, and I think that this is probably a question you've been asked already, and that is the processing of PMNs. There's a question about whether we're going to return to a 90-day review period for PMNs.
Whether we're going to what? I'm sorry?
Return to a 90-day review period. 90 days.
For new chemicals?
Yes, for new chemicals.
So typically, when our reviews take longer than 90 days, it's because the company submitting the pre-manufacture notice has asked us to suspend the review because there is more engagement with the agency that has to take place. I don't have today's statistics at my fingertips, but I know that as of at least a couple of weeks ago, we had fewer cases awaiting decisions than were in the queue when the last administration declared victory over the new chemicals backlog, right? So we're still kind of under that, that threshold that the last administration set for itself when it said that it had solved the problem. So that said, I do believe that, we still need to do better when it comes to new chemicals reviews. We do want to do better. We want to improve our efficiencies. We want to streamline our processes more. And we want to work with PMN submitters to, kind of before they submit the PMN so that we can communicate what our expectations are and what gaps they might want to fill before the clock starts.
And I think that's a good point. I think that one of the reasons why some of these processes tend to be prolonged, in my experience, and I don't think things change very much over the years, is that when the expectations are not 100% clear and things have to be redone, then that inevitably does result in delays. As another question, and I think that this one is almost existential, but but I think it's still a very important question to many people who are on right now, and that is, what is possible and practical that in terms of the review of conditions of use, the distinction between all conditions of use versus all foreseeable conditions of use, and where you as a leader are drawing the line in terms of what you expect to see for a decision in terms of the conditions of use for a chemical.
This was something that we talked about a lot when we were writing law, and the law says reasonably for. So it all comes down to adjectives and adverbs, who thinks something is more reasonable than someone else. And, at a certain point, there'll be a divergence, and someone will think that one administration has left out too much. Another person could think that a new administration is bringing in too much. But ultimately, it's really about what reasonable is. I don't think it's quite as absolute as that question implies.
As another question about a completely different area, the EPA's website, it is asserted, is difficult to navigate. I think that's probably always been the case, especially the website, for this program. I have to tell you that I can recall when a lot of the information on the website was on index cards, and there have been tremendous gains made in being able to get that information, but there is so much information that is out there relevant to chemicals and pesticides. And what is your approach to making that information available on the web, and in particular making it more transparent what's going on in terms of planned rule changes? I think is the point of the questioner as well.
So, I think I see in the chat, PIP 3.1 is sort of attached to this question a little bit from some of the questioners. And I think that's a great example to use because, the last administration finalized those 5 PBT rules. One of them was PIP 3.1. They went through public comment periods. They, released it on, the listserv that exists for people who are interested in TSCA goings on. They did press releases, they did consultations, they did webinars. In my opinion, they did all the things. And yet, within a couple of weeks of my arrival at the agency, it became extremely clear to all of us that there were a large number of stakeholders that were unaware of it, or just didn't think it applied to them. And, so we've met with a lot of those stakeholders. And as many of you know, we took some steps to address that apparent communications failure. But I just want to say that failure wasn't about a lack of effort. I really do believe the last administration did everything right in its stakeholder engagement efforts on those. I guess, surprised by that. And we absolutely want to avoid it going forward. And so, as I've talked to stakeholders, particularly industry stakeholders in the last few months, we've kind of said to them, tell us how better to communicate, tell us what things we could do that would make it easier, more transparent, and more clear, whether it's on our website or whether it's in our press releases. And so we really are trying and hope that anyone with suggestions will bring them to us.
That's really a great approach to take. And, it's an issue, I think, largely of the ecosystem as well, in terms of you work with certain stakeholders, you have certain information on your website, but how does that end up becoming filtered out to everybody who needs to know about it. And obviously, and at least in that case, there were blockages in the communications network. I do see, as one of the comments, somebody asking just, how do I get on, sign up for the listserv, that they didn't even realize there was one. So that's a very fundamental communications issue, and one that I think a conference like this can help to address. And I think kind of validating the need to have conferences like this. We're not going to have time to go through all these questions. There's so many of them, and I'm going to have to just select, I think, one more to ask you. But it's a very fundamental question, which is actually how many staff members are there, and do you feel that you are adequately staffed to implement TSCA? I think it's a fundamental question.
It's a very fundamental question, and I'd say that right now the answer is no. I'd say right now there's, I'm trying to remember our, the numeric specifics of our budget requests, but we did ask for more funding and more people. I do think that we, when I go through and look at what our staff believes they need compared to the numbers of people in each division, there are deficits across the board, not just in the TSCA part, but in the pollution prevention part and in the pesticides part too. And I think, that is also true for new chemicals, frankly. And one of the reasons why the last administration was late, I think, on all 10 risk evaluations, why it is in part why it is harder to make our new chemicals approval process more efficient. It's a real challenge. And I just, again, want to go back to the career staff and how dedicated they are and how hard they work. But they really are stretched pretty thin.
Thank you for that. And I think that's our last question. I want to say that there's so many questions and comments in the Q&A and the chat boxes. And if it's okay with Hugh, Nikhil, I think that we will copy all of those and make them available to your office, just so that you can see, the kinds of issues that people are curious to hear about, and that might be helpful, especially to your communications team as they think about the issues that people in the community want to hear about. I can't thank you enough for taking your time, which is very valuable right now, to be with us this morning. I know that there's several people from EPA who are with us all day, and I'm guessing that you can't be, but thank you so much. And especially thank you for your willingness to step up to do this job. Your job has been described by many as one of the most difficult jobs in the federal government. And I have to say, I concur with that.
I was just going to say, you would know.
So there's a tremendous number of decisions that Dr. Friedhoff has to make every day. Just for those of you on the line who don't know this, they are complex. The easy decisions, 99% of the decisions her office makes are made by career staff. The ones that come to her are extremely complex in terms of the science, the policy, the trade-offs that are involved in those things. And I very much respect you, knowing as much as you know about this world, that you're willing to step up to the job and do that. Thank you so much for your willingness to serve the American people in this job. And with that, I'm going to turn things over to the ELI to move us forward with our panel. Thank you.
Thank you.
Thank you so much, Dr. Friedhoff and Dr. Goldman. We will now jump right into our first panel. So at this time, I invite all of panel one to turn their camera and microphone on. Once again, full bios are posted on our website, and I am so excited to introduce the moderator of today's panel. Bob Sussman is the principal at Sussman & Associates, a law and consulting firm that offers advice and support on energy and environmental policy issues to clients in the nonprofit and private sectors. Bob serves as counsel to Safer Chemicals Healthy Families, a coalition of nonprofit environmental and public health groups. Bob, we are so delighted to have you here moderating, and with that, I will turn things over to you. Thank you.
Yeah, thanks, Chandler. It's great to be here. I see that my video has been blocked, and there it is. So I'm on the screen, and you can hear me as well. It's fitting that our first panel today is on TSCA risk evaluations. The risk evaluation process is the heart and soul of TSCA reform. As you heard from Lynn and from Dr. Friedhoff, Congress wanted EPA to significantly accelerate its examination of the health and environmental impacts of chemicals of concern. Risk evaluations are the prerequisite for risk management and drive the scope and severity of the restrictions EPA must impose. Under the last administration, EPA completed 10 evaluations, meeting the statutory target, although not as quickly as Congress directed. Now the law requires EPA to conduct 20 more evaluations by the end of 2022 and evaluate 4 more chemicals nominated by industry within the same time frame. Since we completed the last administration and embarked on the transition to the Obama EPA, the central question on the table has been whether the first 10 evaluations satisfied the requirements of the law or were insufficiently protective of public health. This question is related to 2 other questions. Should the first 10 evaluations be revisited, and what changes in approach should be made in the next 24? I think you heard from Dr. Friedhoff where EPA is landing on those issues and what direction it is taking. And her comments provide an excellent jumping off point for this panel. We have a very qualified panel to shed light on these issues, and I'd like to introduce the speakers. First is Ryan Cara. Ryan is a principal at the law firm of Beveridge and Diamond. He is deeply involved in TSCA implementation for the firm's clients. He has a PhD in organic chemistry from the University of Illinois and a law degree from the University of Virginia. Next is Dr. Penny Fenner-Crisp, who had a distinguished 2-decade career at EPA in senior science positions in the pesticide and chemicals program. Penny is a leading member of the team of ex-EPA employees who are providing feedback to the agency on the TSCA program through the Environmental Protection Network. Dr. Suzanne Hartigan is Senior Director, Regulatory and Technical Affairs at the American Chemistry Council. She has a PhD in organic chemistry from the University of Maryland. For the last 15 years, she has held senior positions on science policy and regulatory affairs for leading trade associations, including a stint at SOCMA, working on PMN and other TSCA issues. Finally, Jonathan Kalmus-Katz is a supervising attorney in Earthjustice's Toxic Exposure and Health Program, specializing in TSCA. An experienced litigator, John has emerged as a leading architect of the NGO community's legal challenges to TSCA risk evaluations and other actions, and is a strong voice for his clients in the EPA administrative process. We'll now burrow into the key issues, and I should mention that we have a series of questions that we're going to pose to the panelists. We've designated one member of the panelists to be the kickoff speaker on each of those issues. And after that member offers his or her views, we encourage all the other panelists to respond and jump in. I don't think we're going to have time to address questions from the audience, but I know that many people do have questions, and I would really encourage you to submit those questions to the chat box. And if they're not covered during the panel, we will do our best to try to get back to the questioners after the end of today's conference. So let's get started with the first question. It's really the key question, and it's one that I think Dr. Friedhoff answered very categorically, but it's not necessarily a question on which there is unanimous agreement. The question is whether EPA met the statutory objectives in the first 10 risk evaluations. In other words, were those evaluations adequate to determine unreasonable risk to health and the environment, or were they incomplete and underprotective? And I'm going to ask John Kalmus-Katz to start the discussion on that issue.
Thank you. And first off, I want to thank Bob for moderating this panel, my co-panelists for joining me today, and ELI for putting on this event. The short answer to your question is no. I agree with Dr. Friedhoff that none of the first 10 risk evaluations satisfied EPA's statutory obligations or provided a complete and accurate picture of the chemical's true risks. Now, a lot of hard work went into those evaluations by dedicated career scientists. However, because of the decisions that were made and imposed by the Trump administration leadership, the risk evaluations themselves were unscientific, misleading, and riddled with mistakes and errors. Those aren't my words. Those are the findings of EPA's own Science Advisory Council, including many members handpicked by the Trump EPA itself. So to understand where these risk evaluations went wrong, it's important to understand what the amended TSCA requires. TSCA mandates a comprehensive evaluation of a chemical's risks for manufacturing through disposal, not just for the environment and the general public, but also for all subpopulations who face greater risk because of their increased exposure or susceptibility. If a chemical is released to the air or present in drinking water, EPA must evaluate the risks associated with those exposures to determine if they are unreasonable. If people are exposed to a chemical from multiple routes, such as breathing it and touching it, or for multiple uses, EPA must consider those known and foreseen combinations of exposures in its risk evaluation. If communities surrounding the facilities where the chemical is released, has been disposed of or spilled, face greater risks because of their increased exposure, increased susceptibility, or both, EPA must account for those increased risks in its risk evaluation. And if a chemical has previously been spilled or disposed of, but continues to migrate through the soil or groundwater, resulting in continuing exposures, EPA must evaluate those risks under TSCA as well. EPA did not comply with any of those requirements in the first 10 risk evaluations. And these were not isolated mistakes or omissions. They were systematic violations of TSCA. As a result, each of the risk evaluations understated the true risks posed by those chemicals. And the current administration is now facing the difficult task, which Dr. Friedhoff described, of moving forward with the 24 new risk evaluations, while at the same time having to go back and fix the mess left by the last administration. So I agree with Dr. Friedhoff's answer to this question. I think that despite the hard work of a lot of career EPA scientists, the first 10 risk evaluations fell short legally and scientifically.
Thanks, John. Let me ask for responses to John's comments, and I would ask panel members to simply raise their hands, and then we'll call on you for your response. So Ryan, you're the first hand up. I turn it over to you.
Thanks, Bob, and thanks, John, and thanks for having me here today. I know there were a lot of concerns with the risk evaluations, and it would be good to see EPA address them if and when it takes a second look. And it seems like it's very much a win at this point, particularly regarding operational exposure. So there were cases where EPA's conclusions in a proposed risk evaluation were different than in its final risk evaluation, although the underlying science didn't change. And there was something wrong there. There were concerns there. The stakeholders were not given an adequate opportunity to comment. And I know some stakeholders went ahead and did comment on the final risk evaluation, in addition to the proposed risk evaluation. And in some cases, EPA employed what I believe were incorrect assumptions and understandings about how a chemical is used and how a product containing a chemical is used and disposed of, and what the chemical's properties are, and therefore how likely it is to be a workplace exposure. And finally, there are some significant concerns that EPA may assume for purposes of the risk evaluation that employers are not following OSHA standards. And I know there are a lot of concerns about that among the stakeholders. So I echo John's sentiment that stakeholders appreciate all the work that has gone into these risk evaluations. EPA has been going like crazy since the statute was amended, and Congress expects that to continue. And I know EPA is up for the challenge, and the goal is incremental improvement. But it would be nice to see some of these things addressed as EPA redoes these risk evaluations.
Thanks, Ryan. Penny, I saw your hand up.
Yes,
And Suzanne, I saw yours too, and we'll get to you in a second.
the point I was wanting to make was this is an opportunity to talk about the failure of the agency to make use of their enhanced capabilities under Section 4, imposing testing and other information and data requirements early on before the risk evaluations were very far along the way. And we find that for virtually all 10 of the chemicals, there was some significant data lacking to be able to do a full enhancement, a risk assessment for that particular target. Most all of the environmental assessments were under evaluated, often missing ecosystem targets that would have been key to understand about. And I attribute it to the admonition from the administrator that they have to reduce the request for animal testing, even though the transition to the new assessment methodologies had not been made yet.
Thanks, Penny. Suzanne, let's go to you.
Thank you, and thanks for the opportunity to participate today as well. A few thoughts on this question. Maybe a lot of this is kind of pointing back to things that have already been said, but just in thinking about this larger question about statutory objectives, it made me kind of look back at the language that's in Section 2, which is maybe broader TSCA, but we can point to some language there that addresses the congressional policy and intent. And so there are some points under policy where they talk about the importance of the development of adequate data and information, and the responsibility to do that, the adequate authority that should exist to regulate chemical substances, as well as the authority that should be exercised in such a manner as not to impede unduly or create unnecessary economic barriers to technical innovation while fulfilling the primary purpose. And then the section on intent of Congress also kind of gets to the importance of considering environmental, economic, and social impacts of actions that the administrator takes. So I guess, just to point out here kind of as an overarching point that it would be helpful to see EPA demonstrate greater recognition of this responsibility to balance the consideration of health, environmental, and economic and social impacts of its actions with the implementation of TSCA. I think I'll come back to the TSCA amendments providing EPA with the scientific standards, meaning that to the extent that decisions are made under TSCA, they have a mandate. Oops, sorry, maybe somebody's not muted. To use scientific information methods or models in a manner that's consistent with best available science and based on weight of the scientific evidence. This is something that was mentioned, but EPA made a lot of assumptions throughout the first 10 risk evaluations, particularly with respect to occupational exposure assessment and scenarios. And while we understand that in risk assessment, models and assumptions are, can be necessary and can be useful tools, I would say that many of the assumptions that EPA made are based on extreme scenarios that do not represent realistic conditions of use in the workplace. And use of these kinds of extreme scenarios and assumptions don't provide risk characterizations that are then based on best available science. And so EPA needs to recognize that these unrealistic scenarios and assumptions can have a deleterious impact on innovation in the economy and society. Quickly regarding weight of scientific evidence, EPA uses the term systematic review in their definition of this, and we did have concerns about EPA's implementation of systematic review methods during the risk evaluations. We may come back to this a little bit later, but we understand that EPA is updating their guidance in this space, and stakeholder input will be important here to help ensure that EPA is meeting those requirements for use of a weight of the scientific evidence. And then finally, I'll just add that EPA does have an ongoing mandate to develop policies, procedures, and guidances that are necessary to carry out the amendments. And EPA has put out some guidance, including guidance for manufacturers requesting risk evaluations and the systematic review guidance that I mentioned. But however, the requirement, I think, provides an opportunity for EPA to get further feedback on the general approaches that it's using in the risk evaluations. And so I think there's opportunity for EPA to utilize that as well to put that out there and get feedback from stakeholders as well. I think I'll stop there.
Yeah, thanks, Suzanne. Let's move to the second question. As you heard from Dr. Friedhoff, EPA has in fact decided to revise several of the 10 initial risk evaluations to remedy perceived deficiencies and provide a more robust basis for risk management. So I think the question is whether EPA is making the right decision here. Is this the best approach? Should EPA put the 10 evaluations behind it and focus its resources on risk management? Or is it better to address limitations in the evaluations to enhance the effectiveness of risk management? And Susan, I'm putting that question to you.
Thank you. So I guess I'll start off by saying that certainly the goal for all of the risk evaluations should be to have strong, good quality assessments that can serve as a strong basis for risk management. And so in general, the risk evaluations should have sufficient detail to allow the risk managers to effectively and efficiently move and develop risk management proposals for those conditions of use that were determined to present unreasonable risk. But we also want to acknowledge that right now the next batch of risk evaluations is already underway. And so EPA should be moving forward and making progress on those risk evaluations, and not necessarily going backwards. However, if we're hearing now that if it does decide that it needs to look back at those initial 10, then it should be open to looking at the comments of stakeholders and peer reviewers and re-examining other aspects where the risk evaluations fell short. I guess also EPA should consider new information that's brought to them as part of the risk management phase that may be able to give more clarity in certain areas. We already talked about some of the assumptions that were made. Information can be brought that can refine those areas where assumptions were made and provide more information there, and that should be considered. And while ultimately it's EPA's decision whether or not they're going to reopen them or supplement them, I just would encourage that if they do so, they consider other relevant information that could further refine them. And then also encourage that any changes that EPA makes in process or on a chemical specific basis should be made publicly available for comment and allow stakeholders to provide feedback.
Thanks, Suzanne. Any other comments on the decision to revisit the first 10? Ryan?
I guess I would just very briefly underline the last thing that Suzanne said. There were some stakeholder comments that I think are critical that were submitted in response to the final risk evaluations, not just the proposed risk evaluations. So it seems the decision has been made to take another look at these risk evaluations. And my hope is that EPA takes a close look at all the comments that were received, including on the final risk evaluations, and builds that into both the risk evaluation process and when they're starting to take their first looks at risk management.
Great. John, I'm going to turn to you now because I know you've been deeply involved in the challenges to 3 of the completed 10 risk evaluations. And my question to you is EPA moving in a direction that you think will address all of the concerns that motivated you to file these cases, and related to that, now that EPA has set a course and has provided a plan for moving forward, is it necessary to get judicial decisions on these issues?
So that's a good question, and I don't think there is a single answer. I think that I agree kind of with what Mihal said and with what Suzanne acknowledged, that the decision about how EPA goes about kind of fixing the mistakes in the first 10 risk evaluations can be chemical specific. Kind of, there's not necessarily a one size fits all approach that is going to apply across the board. With respect to what EPA has proposed doing in response to the methylene chloride risk evaluation lawsuit and the HBCD risk evaluation lawsuit, and I guess 1,4-dioxane, it has also moved for remand to revisit some of these issues. I mean, you could see from the opposition to the first 2 of those motions that the list of issues that EPA has proposed reconsidering upon remand does not address all of the flaws in those risk evaluations. In fact, if you look at HBCD, and I think Dr. Friedhoff acknowledged this in her remarks today, they are contemplating extremely limited changes to that risk evaluation and are really not addressing or not proposing to address any of the concerns that are raised by 2 of the 3 petitioner groups in that lawsuit. So I think that EPA is right to go back and to fix these changes. I think that fix these errors. I think that whether through risk management or kind of a surgical reopening of certain risk evaluations, there certainly are issues that need to be addressed. But I think that the mistakes go beyond what EPA has identified in its remand motions. I do think that there are significant errors that need to be addressed that are not covered in those motions.
Thanks, John. Any further comments on this question? If not, we'll move on to the next question, which also leads us back to Dr. Friedhoff's comments about the future direction that she plans to take, not only on the first 10 evaluations, but presumably the next 24. So as she explained, EPA is now adopting a whole chemical approach to risk evaluations, in which it no longer makes use by use determinations of unreasonable risk, but finds that the chemical broadly does or does not present an unreasonable risk. So the question is this concept the best reading of TSCA? And then even assuming that it is, how should it be operationalized in conducting risk evaluations? What are the implications of the whole chemical approach? And Ryan, we're going to start with you on this one.
Sure, thanks, Bob. So the statute, we'll go back to the statute first, which requires EPA to, quote, determine whether a chemical substance presents an unreasonable risk under the conditions of use. And so that this is relevant to the whole chemical or use by use question. And I know the NGOs have argued in past litigation, since the statute says EPA must determine whether a chemical substance presents the risk and not whether a use presents the risk, that weighs towards the whole chemical approach. But one might reasonably argue, and some have, that the fuller phrase is chemical substance under the conditions of use gives EPA sufficient discretion to decide between a whole chemical approach and a use by use approach. So that was back when EPA seemed to be leaning towards a use by use approach. So the Ninth Circuit found that issue in 2019, I believe, to not be justiciable yet, because EPA had not yet picked a lane. But there's a possibility that it's justiciable now, since EPA seems to be publicly stating that they're going to go for the whole chemical approach. It's also worth considering here how this affects the timing of challenges to risk evaluations. So under the use by use approach, it was a bit complicated. So finding of no unreasonable risk could be challenged right away. And it was in many cases, as was just mentioned, at the risk evaluation phase. But a reasonable risk can't be challenged until the risk management rule comes out more than a year later. So you've got portions of a risk evaluation that are ripe for challenge right away and portions that need to wait a year. And from a public policy perspective, this has presented a challenge because it has allowed those who are challenging findings of no unreasonable risk to select the federal forum of their choice, whereas those wishing to challenge the other conclusions have to wait. So it's now worth considering whether under a whole chemical approach, whether challenges to no unreasonable risk determinations are premature. So I'll stop there. I'm sure my co-panelists are going to have a lot to say about this question.
Other comments on the whole chemical approach? I'd be interested in hearing what the practical consequences of this are. Ryan certainly identified one, which is the timing of judicial review and when issues are justicable and when they have to wait until the completion of the risk management process. But there may be other important consequences that need to be examined as well. So, John, I'll turn to you on this one.
So as Ryan mentioned, we do believe that a whole chemical approach is most consistent with the text of TSCA, which requires a risk determination for the chemical substance. And I think there's a good reason for that. I don't think that was accidental phrasing. Consider a chemical which has multiple uses. It can be used in both paint products and paint removal products, paint strippers. And this isn't just an abstract kind of hypothetical. There are first 10 chemicals, including methylene chloride, which have both of those uses. EPA defines those as separate conditions of use. Moreover, both of those uses can be done on the job occupationally and at home by consumers. So now you have not one condition of use, but four. You have commercial painting, commercial paint stripping, consumer painting, consumer paint stripping. It's entirely possible that for this chemical, no individual condition of use would necessarily present unreasonable risk. It is also possible, if not reasonably foreseen, that there would be people who would be engaged in more than one and potentially all four of those uses. You have construction contractors, handy people that both strip paint and paint on the job. And then when they go home, odds are, if they need work done in their house, they're not hiring somebody. They are using paints and paint strippers at home. So a use-by-use risk determination, which looks at each use in isolation, is going to leave those people exposed to unreasonable risk. And I think that is fundamentally inconsistent with the purpose of TSCA. I think that this whole chemical risk determination is required by TSCA and is really the most scientifically defensible approach. I agree with Ryan that this may have implications for when certain EPA determinations can be challenged. I mean, obviously, if EPA finds that a chemical as a whole presents unreasonable risk, there are different provisions governing that under TSCA, and we'd have to look at that on a case-by-case basis to determine kind of the appropriate timing and kind of means of judicial review. But I do think that this is an important shift. And it's not to say that conditions of use are insignificant or should be ignored. I mean, I think that what Dr. Friedhoff outlined is exactly right, where EPA certainly analyzes the risks associated with each condition of use, but then it also looks at the risks to people who are exposed for multiple uses and makes a holistic determination for the chemical as a whole.
Thanks, John. Suzanne?
Thanks. Yeah, I'll come back to this conditions of use issue a little bit as well. You know, and this shows up quite a lot throughout the statute. It's clearly an important concept in risk assessment and in risk evaluations. But just to kind of talk about that a little bit more, this is really the context in which a substance is used. So it's critical to understanding its potential exposure and therefore its potential risk. And therefore it's going to be critically important to have considerations for the individual conditions of use assessed during that risk evaluation phase in order to provide that strong basis that we keep talking about for setting up the risk management efforts. Again, sounds like that's Michal acknowledged that, and you know, but during that part is important to their risk evaluations. But if we think about the steps for a risk evaluation, there's a risk characterization and then a risk determination. I think we're talking about the risk determination here, and this is important to feed into that determination as well. You know, and John gave an example in a specific case, but I think we want to be mindful that TSCA does, you know, cover a broad, diverse set of chemicals with a broad, diverse set of uses, and you know, a broad, diverse set of physical chemical properties. And so it really does require you know, a case-by-case basis, a specific look in a lot of these cases. And so, you know, listening to what we're talking about this morning, there are probably a lot of questions raised at, you know, right now about that direction. I think we need a little more detail on that going forward, but without knowing all the details, I think I just want to caution that we could expect that any approach that doesn't pull back to those specific conditions of use that led to the risk characterization would, you know, to inform that determination would present significant risk communication issues and challenges associated with, you know, communicating that a determination was made on a whole chemical, but not sort of pointing back to the specific circumstances that lead to the concern or the drive for risk management.
Thanks, Suzanne. Penny?
Yeah, I have a question within the question. If one has to wait until you get to the whole chemical thing, we found for several of these chemicals, as the use by use determinations were made, not the risk characterizations, not the determinations. That the scenario constituted an imminent hazard, and TSCA has an opportunity to take earlier actions on those that are imminent hazards. There was an example of 1-BP and methylene chloride, among others. How would that opportunity for early risk management proposals be affected if you had to wait to the whole chemical approach after everything is done?
Yeah, that's a great question, Penny. Anybody want to take a shot at it? John?
I think it is a good question. There is separate authority under TSCA. TSCA Section 7 gives EPA the authority to address imminent hazards, and that is separate from its risk evaluation authority. There kind of may be cases, chemicals in which kind of the risks posed by a condition of use are kind of so clear and so imminent that moving that specific use to risk management kind of does kind of make the most sense. And I think that the framework rules briefing kind of identified circumstances in which that would be permitted, but I don't think that that should be used as an excuse to let EPA kind of generally just conduct these fragmented risk evaluations where you look at individual conditions of use solely in isolation and do not consider real world combinations of exposure. So I think EPA can do both. I think that it's a good flag, and there's certainly sufficient authority under TSCA for EPA to quickly address imminent hazard while at the same time conducting the sort of holistic risk evaluations the statute contemplates.
Great, thanks, John. Let's move on to the next question, which involves another critical issue that Mihal addressed, and that is the decision she and the agency are making to, in essence, eliminate the exclusions in the original 10 risk evaluations for environmental pathways of exposure. The theory of the last administration was that it's redundant to use TSCA to address releases to air and water and waste because these releases are within the purview of other statutes and other significant EPA programs that are in place. So I think the question to the panel here is it wise for EPA, as Mihal outlined, to expand the scope of TSCA risk evaluations to include these environmental exposure scenarios? And Penny, we're going to start with you on this one.
Yeah, I would point out that the exclusion of these other environmental pathways for TSCA evaluations preceded the Trump administration. There are other examples, a few examples where the program had done some existing chemical evaluation. They also excluded this. And that's actually the standard practice across the agency with minor exceptions. Most folks who are developing media-specific or chemical-specific assessments under their home legislation, like if you work in the air program or the pesticide program, want to use the whole risk cup for themselves. In other words, make decisions based upon the scenario that they're focused on. That's true in the pesticide program, and that's true in most media programs, with the exception of the water program, which does, when defining health advisories, MCLGs, which are the health goals that precede the drinking water standards, or development of human health ambient water quality criteria, do take into consideration other pathways by imposing what they call a relative source contribution factor. They're generally defaults, but they can be refined if you have information that's specific to the chemical that's being evaluated. So the question becomes, if all of the programs are doing that and reserving the 100% of the risk cup for themselves, what is the agency doing globally with respect to human health protection? If everyone is using the 100%, that means that the other ones are in excess of acceptable, whatever an acceptable standard may be, 1 in a million for cancer, exceeding the reference dose for a non-cancer effect. So I was heartened to hear Dr. Friedhoff note that they were going to go back for some of these chemicals and take into consideration some of the environmental pathways that theoretically other laws in the agency would develop standards for. I think those are 2 separate tasks: standards development for the other media and consideration of these exposures within the TSCA realm.
Yeah, thanks, Penny. Listening to Mihal, I wasn't sure whether all environmental exposure pathways are going to be incorporated in TSCA risk evaluations, or whether some will be imported selectively based on the magnitude of exposure and the regulatory status of the chemical under another EPA program. So I'd be interested in what the panel members thought about that, and whether Mihal's approach is a comprehensive approach or a chemical specific one.
I got the sense that it was chemical specific. She mentioned a few chemicals. I didn't hear her say we're going to do this with all 10 or the next 20.
Okay. If that's the case, is Mihal going far enough in the direction of comprehensive risk evaluations, or is this more targeted and limited, and is that a good thing? Ryan?
Yeah, I think that's a tricky question, Bob. I think what I will say is, to the extent that EPA decides to carve out air, water, waste pathways from risk evaluations, there might be a good legal basis to do so. There's no statutory requirement to consider all conditions of use in a risk evaluation. It's pretty clear to me that EPA has discretion. The statute defines condition of use as determined by the administrator. It requires EPA to describe whether aggregate and Sentinel exposure are considered in a risk evaluation. So there's discretion, and it's good policy. There's a reason the statute was drafted that way, because there are other statutes for that. And there's good legislative history saying that the agency has discretion to consider conditions of use to ensure a focus on the greatest potential for risk. So I don't think it was the intention, and it can't have been Congress's intention, for TSCA reform to have TSCA supplant and subsume all the other environmental laws.
John, comments on this?
Yeah, yes, thank you. So just quickly in response to that, I think that we have a very different reading of TSCA than Ryan. EPA does not have the discretion to exclude conditions of use that fall within the statutory definition provided under TSCA. I think that was certainly what the Ninth Circuit found in the Safer Chemicals case, where it said the ability to identify conditions of use refers to the administrator's obligation to apply that statutory definition. The administrator is the one who determines what the conditions of use are, but it said that the regulations in the statute unambiguously do not grant the administrator the definition, or the authority, the discretion to exclude conditions of use. And I think it's important to note that Congress enacted TSCA after the Clean Water Act, Clean Air Act, Safe Drinking Water Act were passed, in recognition of the fact that those media-specific laws were not sufficient to comprehensively evaluate and regulate the risks associated with toxic chemicals. I think that Penny gave a very good description of why that is, but there clearly are chemicals that are subject to regulation under other laws, or that are even regulated under other environmental laws. There still are significant releases to the environment, to the air, to the water. I mean, methylene chloride emissions to the air, 1,4-dioxane in drinking water, an area where EPA has taken no action. So I think the mandate of TSCA, what TSCA requires is that EPA consider, notwithstanding those laws, are there still exposures ongoing, releases ongoing that pose unreasonable risk? And if so, EPA has to address those risks. It's not sufficient to say, oh, well, we have another law that could address this. TSCA gives EPA the authority to do so and really the mandate to do so. So I think that EPA should be looking at all exposures associated with the chemical's conditions of use. It should be looking at all conditions of use.
So you would say, John, that this should not be chemical by chemical. There just should be a presumption that for each risk evaluation, all environmental exposure pathways will be considered.
Yes, I would say not even a presumption, but a mandate. I think that if you read TSCA, what TSCA requires is a comprehensive evaluation of the chemicals risks. So that doesn't mean that all chemicals will present unreasonable risk for each of these exposure pathways, but it does mean that EPA has to look. And to the extent that the Clean Air Act has not addressed unreasonable risk, to the extent the Safe Drinking Water Act has not addressed unreasonable risk, there are options during the risk management process. If EPA thinks that another office can handle the risk, it can kind of consult with that office. It can effectively make referrals to kind of tell the Office of Air and Radiation, the Office of Water, we think that you should go further. We think that you should strengthen your regulations. But in order to determine whether that is needed, EPA must first evaluate the risks associated with that pathway. So it could determine how much regulation is needed. Are there unreasonable risks that warrant further action, either under TSCA or one of these other laws? So I think that the exclusion of exposure pathways is just categorically unlawful. I don't think that a chemical by chemical approach to this issue is appropriate.
We're almost running out of time, but there's one question that a couple of audience members have asked that I wanted to get very quick responses to. And the question is this, which is whether if EPA moves to the whole chemical approach, there is a possibility that the public will think that every use of a chemical is unsafe, when in fact the concerns may be focused on a particular subset of uses that represent only a reasonably small portion of all of the uses of the chemical in commerce. Anybody want to comment quickly on that?
Well, I can just add, this is Suzanne, I can just add that I tried to get to a little bit of that concern in my comments earlier. Again, it's a challenge, and I understand, that there can be a variety of diverse uses that the agency needs to look at and consider in these, and it is a challenge to, risk communication is always a challenge, but simplifying it too much, I would be very cautious of concerns that people would not understand the conditions under which you would actually see that risk.
Any other quick responses to that question? Okay, well, yes? I guess not. We are out of time for this panel, and I wanted to thank the panelists for being here today and for their excellent insights. And now I think we're going to take a very brief break and come back at 11 o'clock for the next panel. Thanks again.
Thank you all.
Hi, Jeff.
Hi, Randy. How are you?
I'm fine. How are you?
Good, good.
Hi, Jeff. Hi, Randy.
Hi. We don't see you yet.
Oh,
There you are. Hi, Sarah Beth.
hey, Jeff. How are you?
I'm good.
Hi, everyone. This is Kimberly.
Hi, Kimberly.
Kimberly.
Are all the panelists women on this panel? That's pretty unusual.
It would appear so. Oh, we've already got a question from the audience. We haven't even started yet.
Are we just speaking
morning,
among
Mrs.
ourselves now, Jeff?
No, everyone is able to hear us at the moment.
All right.
Yes,
Okay.
we just want to make sure everything's working tech-wise. If anyone needs to, get off camera for a moment and grab some water or anything, please feel free to do so. It looks like everyone's camera and microphone is working, but we will start promptly at 11. And Jeff, I will just do a very brief introduction for you and then hand the reins over.
Okay, question on that. The previous panel had the names of the panelists up on a slide. Do we have that for this one?
Yes, we do.
Thank you.
Should we do like just a quick mic check? For example, do you guys hear me okay?
Yes.
We hear you
Okay, good.
great.
Okay, excellent, thanks.
All right.
Right, well, we can go ahead and get started for panel 2. Welcome back, everyone, from the break. I have the honor of introducing the moderator for this upcoming panel on risk management. Jeffrey Morris is the principal of Jeff Morris Solutions. Jeff previously served as director of the EPA's Office of Pollution Prevention and Toxic. Thank you so much, Jeff. And with that, I will turn things over to you to kick off panel 2. Thank you.
Chandler, thank you very much. And it's a pleasure to be with you all to talk about risk management. As you can see, we've got a great panel lined up for today. I encourage you to go look at their bios on the website, but we're going to jump right into the interest of time because we have lots to cover. And I want to just start by pointing out that while existing chemical risk management is not new to the agency. It's not new to the TSCA program. 5 years ago, the Lautenberg Act set up the first actual program for risk management, moving from discretionary to required deadlines, schedules, etc. So now we've got an actual program that we're beginning to implement. And here is where environmental protection and health protection really begin to happen after years of study, of evaluation, prioritization. Now here we are, and we've already seen with the PBT rules and PIP 3.1 being an example of how complex the risk management issue can be and the communication challenges that arise from it. And as we know from risk evaluation, in risk management, we're going to see a number of stakeholders with equities in the chemicals under risk management engage with the agency and other stakeholders on how to proceed with addressing risks identified through the risk evaluation process. Other federal agencies, state agencies, local governments, even international and other national jurisdictions will be highly interested in what the agency does for risk management. And we can see in the statutory language of Section 6A and looking at those 6C2 provisions that get into the requirements for risk management, that the statute was intended to seek approaches that were both protective and practical, to not trade one social ill for another. For example, addressing risks, but then imposing undue economic hardship. And this is a challenge because the EPA's mission is to protect human health and the environment. So working within a construct that includes these other considerations in the risk management stage raises particular challenges. And nevertheless, that's the program that we'll be operating under. And so it's important that as we do that, we see this as one additional new aspect of the program that we're implementing. And I say we because all of us, the agency stakeholders together, need to work together to find the right balance that is in the statutory language to address the risks that are identified in a way that meets those statutory requirements. Now, as we do this, as we've already seen from 5 years implementation of the program, that the actions that the agency proposes and ultimately takes won't be without contention and controversy. That's to be expected, particularly in the implementation of a new statute. But the way we keep moving in a spirit of collegiality and respect, if not always agreement, is continued dialogues like we're having today. They're so essential to ensuring that we work together toward implementation of this important aspect of the TSCA amendments. And so in that spirit, with no further ado, I'd like to begin our panel discussion, and I'm going to direct my first question to Dr. Kimberly White. And Kimberly, the question is this: for those chemicals that are currently under TSCA evaluation, so haven't even moved to risk management yet, and for those on the TSCA work plan that we expect to be evaluated but aren't even into that space yet, what considerations should stakeholders take with respect to risk management at this early point in time?
So thanks, Jeff, for the question. Thanks for moderating this session and for ELI for pulling us all together today for the webinar. I think this is a really good first question to start with because it's important for us to note that the TSCA work plan chemicals are a set of priority substances that the agency looked across certain criteria for hazard criteria, for exposure criteria, and some PBT criteria, but it did not conduct a comprehensive assessment. So just because a chemical is listed on the work plan chemical list doesn't constitute a finding of risk from the agency. And so rather than just identifying the chemicals from the work plan chemical list, the agency has to actually consider that information for further review before it starts to take any risk management actions. I think really though, the work plan chemical list provides a real great opportunity for stakeholders and EPA to collaborate early on in the process and to share information and data. So it really gives us an opportunity before the agency gets into the risk evaluation process or the risk management process to say, what are our data needs on exposure assessment? Are there additional data needs on hazard assessment that are currently available, right? Because again, EPA didn't really conduct a thorough review of the literature at the time for identifying chemicals for the work plan chemical list. It was really a screening level assessment. And so here's an opportunity for us before it goes into risk management and risk evaluation to be able to say, there are data needs. The agency can identify what those data needs are early on in the process and can work with stakeholders to collaborate on that information needs, whether or not there is additional exposure related information that might be informative to an upcoming risk evaluation that would then inform a risk management activity. So I really think that there's a lot of opportunities for direct dialogue with the agency. I think one of the things that you heard, I think, in Dr. Friedhoff's comments earlier was about the engagement in the risk evaluation process and having some of those technical discussions early on. And I think that's what needs to happen now. And I just don't think that you should just move forward just because a chemical is on the work plan chemical list or is even in risk evaluation right now with risk management activities, because you have to understand what the actual risk is before you apply risk management tools.
Thank you, Kimberly. Would other panelists like to weigh in? Eve, yes.
Hi, thanks, Jeff. And I agree that that knowing that chemicals are on the work plan is an important factor that stakeholders need to take into account. And that's because the TSCA statute actually requires EPA to prioritize those chemicals. In every time that it goes through a high priority designation process, it has to select 50% of the high priority designees from the work plan until the work plan is used up. So the chemicals on the work plan will eventually go through risk evaluation. And so I think one of the data points, and I agree with what Dr. White was saying, that this is an opportunity to start gathering the data. I would say specifically, and we've seen this with the PIP 3.1 PBT rulemaking, that one of the real challenges has been the supply chain. So I just wanted to highlight that I think that one of the data points that really should be gathered as soon as possible for the chemicals on the work plan is for manufacturers and processors to understand where those work plan chemicals are in the supply chain. And apparently, based on comments from the PBT rules, it may take many years for that information, that supply chain information, to be gathered. So now is the time to start gathering the supply chain data for the work plan chemicals. And I would also say, I think it's also important that if any of the chemicals on the work plan are not already listed on the toxics release inventory, it's really critical that EPA start the process, the rulemaking process, to add them to the TRI, because that's been such a key source of information for the risk evaluations. And without TRI data, it's unclear how EPA will really assess exposure.
Thank you, Eve. Randy, you have your hand up.
I just wanted to add that I think it's important for EPA to get occupational exposure data with industrial hygiene background information so they know what they're looking at, and that the earlier they start collecting that data, whether they mandate it from employers or whether it's submitted voluntarily, the better off the agency would be, and they would have better and more information to inform their decision making.
Thank you, Randy. Sarah Beth, we've talked already about the PBT rule, but perhaps you could expand a little bit. And as we move forward now more generally with risk management for existing chemicals, are there lessons that we can learn from the PBT rule that can be helpful going forward?
Well, thank you, Jeff, and thanks to ELI for the opportunity to be here. Just to give a quick background, I know it's been talked about a little bit, but back in 2019, EPA proposed a rule addressing 5 substances that it had determined to be PBT. And then in January of 2021, it issued a rule for each chemical for risk management, and it really varied. There were provisions prohibiting processing in distribution and commerce of the substance and products containing the substance. There were some manufacturing provisions. There were also some exemptions. For example, there was an exemption in one rule for certain replacements for parts for automobiles. Then there were various deadlines that ranged from, in a few cases, to the end of the service life of the product containing it, to basically a 2-month implementation. And there was a lot of reaction to that. I think it was most people are aware of. EPA ended up issuing no action assurance letters, a letter in some cases. But what it really has highlighted is the complexity of the supply chain. And that was something that was just touched on earlier, but that it's complex and there are a lot of consequences that have to be considered. So if you're prohibiting a substance that may be used as part of a replacement part, that could result in the premature disposal. It can shorten the life of that substance if people can't get replacement parts. That has consequences, particularly when we're talking about various complex products, whether it be durable goods or consumer goods. So that has impacts. It also has economic impacts, because if the replacement part can't be available, there may not be feasible alternatives. The new parts may be, new equipment may be significantly more expensive. Some users, whether it be consumers or an industry, may not be able to afford it. So I think what it tells us is, it goes back to some of the collaboration. I mean, EPA needs to make sure that it appropriately considers all these consequences, but also companies need to understand what substances are in their supply chain. And as noted, it's one of the things we've learned from this is that's a complex process, and people need to start understanding as soon as they can what is in their supply chain, and then pay attention to what EPA's review schedules are, so that that information can be provided to the agency, because there may be a lot of information that those users have that EPA needs.
Thank you, Sarah Beth. Would any other panelists like to weigh in on the PBT issue and lessons learned? Yes, Kimberly.
Yeah, I just want to build a little bit off of what Sarah Beth said, because I think this is a really important point about, making sure that the agency has a good understanding of the value chain and the exposure scenarios as it's trying to apply risk management and the potential impacts there. I think that, the agency did try to engage industry and other stakeholders throughout the expedited PBT process, but I think there were gaps in the communications, right? And so even though I think they had webinars, they reached out, that there were clearly gaps in the communication and the application and the potential impact of the risk management activities. And so trying to identify where there were those gaps, where we can improve upon that moving forward, so that the agency has a good understanding before it moves forward, And I recognize the PBTs were an expedited situation, right? And so the agency will likely have more time as it's moving forward with these evaluations. And so this was a little bit of a unique situation because of the time frame that they were under, but I think it presents us a good path forward and an opportunity to say, well, here are some areas that we're missing. So how can we bring in those stakeholders early on in the process so they understand where there might be implications for their product being created if this chemistry is removed. I think the other thing that's important here as well is for us to have a good understanding and for the agency to have a good understanding of the risk management that's already in place. And so there is sometimes underneath of some of the PBTs that have been moving forward, already product stewardship that has been in place, already voluntary standards that have been in place that have been worked in conjunction with the EPA and other program offices. So making sure that there's a good understanding of what those are, whether or not they're already sufficiently mitigating the risks that have been identified by the agency. And again, communicating that out to stakeholders, I think in a clear way so that the agency has that and stakeholders have that information very early on in the process.
Thank you, Kimberly. Eve, did you want to? You unmuted. I didn't. Did you want to weigh in?
No, I don't think I have anything to add. I mean, I guess maybe I would just say that, and I do think that the, I don't know that voluntary measures actually satisfy the criteria under 6A. 6A lists out risk management measures that can be adopted, and voluntary measures aren't listed as one of the approaches that EPA can adopt, legally to address risk. And I think the other thing to point out, just specific to the PBTs, is that part of what was unique about that rulemaking, obviously there are many things about that, including that it was, as Dr. White said, expedited, but also that EPA was under a mandate to reduce exposure to the extent practicable. So it's a different risk management standard that, I think really, required EPA to take the steps it took. And in fact, we think it should have gone further with the risk management rules. But I think that it's not clear how much the risk, those risk management rules bear on the next set of risk management rules, just because the legal standard is a different legal standard.
Well, thanks, Eve. And actually, the next question is for you. And I think an important motivator for the Lautenberg Act amendments was the concern that the public did not have confidence under the old TSCA that they and the environment were being protected by the statute. So the question for you, Eve, is how can the EPA ensure that if it identifies an unreasonable risk, that it complies with the mandate under TSCA to ensure that the chemical substances risk is addressed so that it no longer presents risk?
Right. Thanks for that, Jeff. And just building on what I was just saying about the PBT risk management rules, I mean, I think the starting point for this has to be the statute itself, the language of Section 6, and specifically Section 6A and Section 6C. And Section 6A makes clear that EPA must eliminate unreasonable risk that's presented not just by a chemical's individual conditions of use, but also as a result of combinations. And that's the statutory word, combinations of conditions of use in the aggregate. And Section 6 also requires that risk management regulations look at and eliminate unreasonable risks to populations and communities that are at greater risk of harm from the chemical due either to greater exposure or greater susceptibility or both. And that's the case even if the general population's risk is acceptable, if there's a potentially exposed or susceptible subpopulation whose risk is unreasonable for that population given their exposure and susceptibility. EPA still has to regulate to eliminate that population's or community's risk. And in doing so, it will need to take into account that for those populations and communities, even low-level exposures to the chemical that's undergoing risk management may present unreasonable risk, and maybe even lower levels than might be unreasonably risky for the general population, because those communities and subpopulations are particularly susceptible. And that susceptibility may be a function of intrinsic factors such as underlying disease, and also extrinsic factors such as psychosocial stressors, including from living in poverty and living with racial discrimination. So those are some things that EPA needs to take into account. And it's also critical that EPA's regulations adequately account for the risks associated with disposal of the chemical, including future disposal. So if a chemical continues to be manufactured, it will continue to be disposed of. And that future disposal, such as future incineration, needs to be accounted for, as well as the potential future exposure from ongoing presence of the chemical in landfills or underground injection sites. So that just needs to be part of the calculus. And I think it's also important that, that TSCA requires EPA to consider the likely effect of risk management measures on technological innovation. That's one of the specific factors in section 6C2. And I think it's interesting that the focus on technological innovation also dovetails with one of President Biden's executive orders on tackling the climate crisis, which specifically calls for promoting a sustainable and equitable economic future. And so I think based on those provisions, it's important that that promoting a shift towards safer alternatives is a primary driver of EPA's risk management rules. So just to sum this up, I think there's no one size fits all answer to how EPA should apply all these considerations to any particular chemical. Different approaches and even combinations of approaches will be appropriate, based on the chemical. But an important guidepost is that Congress specifically eliminated the requirement that risk management measures be the least burdensome alternative. So EPA is free to select risk management measures that take into account benefits that are difficult or impossible to quantify. But ultimately, as you suggested, Jeff, EPA must take the steps necessary to truly protect health and the environment. And that's what Congress called for. That's why the statute was reformed. And in order to do that, the risk management rules at a minimum have to be clear and enforceable.
Thank you, Eve. Would any other panelists like to comment on this issue of ensuring that risks are addressed completely according to the statutory provisions? Yes, Kimberly.
Yeah, so just building a little bit off of what Eve said, I mean, I think the other thing that's really critically important here is those scientific standards that go into the risk evaluation, right? So the agency has to get the science right in the risk evaluation stage so that it's looking at the right exposure scenarios, that it's evaluating the right hazard information, and that it's incorporating that information to make an actual risk determination. And so I think that's critical. I think that was kind of lacking in the first 10, which is why the agency is likely going back, looking at some of those, that there were, misrepresentations and not using some of the best available science in some of those first 10. And so, the agency has to really make sure that they understand that information. I mean, just thinking about the susceptible subpopulations, one thing, yes, the statute absolutely requires the agency to look at those susceptible subpopulations. One thing that I think gets lost is that embedded into the risk evaluation, kind of the hazard assessment process, is an assessment of susceptible subpopulation conceptually when the toxicity values are actually generated. And so making sure that there's some understanding about how that information is already incorporated in to look at, the outliers within the assessment is one thing that I think sometimes gets lost when we're trying to think about incorporating the additional information for susceptible subpopulations. So like I said, I don't think that gets taken into consideration. It's come up at a couple of the science advisory committee meetings about how to kind of incorporate that information. And again, it's kind of in the weeds and very technical in the process, but I think it's something that needs to be taken into consideration. I think the other thing is, risk management is all about, again, mitigating your risk, right? That has been found by the agency. And we know, as Eve mentioned, that the agency has lots of tools to be able to do that. And so trying to find the right tools that adequately mitigate that risk and that will have, what I would say is substantial public health benefit moving forward, I think are important. And, direct interaction with broad level of stakeholders as the rules are being put in place, I think are really important. I think the agency is trying to do that. as they're putting out, the webinars and discussions that they're having and the meetings that they're having with the agency. But I think there needs to be more of that. I think we heard from Dr. Friedhoff in her earlier discussions about the risk management activities that they will be looking at for some of those first 10. And she talked a little bit about kind of the screening level assessments associated with fence line communities and being able to put that information out for some public comment. And so there's an opportunity for stakeholders to understand, to provide scientific information that can inform that process. So the agency is really relying on what we would consider the best of class approaches and methodologies prior to moving into risk management. And so I think that those are all critically important as the agency moves forward. And I was heartened to hear that they're looking at, significant opportunities for additional stakeholder engagement as they kind of build out some of these approaches and before they actually start implementing them.
Thank you, Kimberly. Anyone else like to weigh in on this one? Okay, if not, Kimberly, the next question is for you. And as was noted in the previous panel, should the agency identify risk with the chemical substance, it has under the statute section 9 the opportunity either in 9A to refer risk management to another agency or under 9B to another EPA program that's relevant to the chemical risk identified. What do you see are the implications of such referrals, particularly within this, what we just talked about in terms of the public being confident that risks will be addressed?
Well, coordination with the other federal agencies, I think, is going to be critically important as the EPA looks at risk management opportunities. I think, as you heard from Dr. Friedhoff, that the TSCA office is understaffed. And so relying on, one, the expertise from some of the other federal agencies and other program offices that, have been looking at risk management activities, have been implementing some of these things for a long time, and coordinating that thinking to figure out what might be the best approaches, I think are going to be critically important. I don't think that the agency has to rely just on itself. I mean, I think that's the point of the coordination. I mean, they put out, I guess, a few months ago about the coordination on new chemicals with the OSHA office. It didn't address existing chemicals, but we should see more of those type of agreements that really clearly lay out how the agency is kind of coordinating with other regulatory bodies that have had responsibility for building out, occupational exposure limits, that have had responsibility for setting emission limits and coordinating those activities and relying on some of that expertise that exists with those agencies. Again, making sure that they're complying with the TSCA statutes and complying with the risk management process that needs to move forward. But when the agency can, and the scientific expertise lends itself to defer to that other agency, I think that the EPA should recognize that and should try to leverage that where appropriate. I mean, I think we want to make sure ultimately that risk management is commensurate to the risk that exists, and that making sure that we coordinate and engage with those other agencies or even within the program offices within EPA, and that those discussions are happening about how they have mitigated risk using technology tools, using closed systems or other avenues. I think are important to have those discussions early on in the process as the rules are being formulated before they're rolled out to the public.
Thank you, Kimberly. Randy, did you want to weigh in on this?
I did. First of all, I can only speak to the process of referral to OSHA because that's where my expertise is. And I'm going to agree with Kimberly. I think that coordination is really important and that EPA has a lot that they could learn about occupational risk management from both OSHA and NIOSH. But I think that the formal process of referral that's described in Section 9 is probably not going to be that useful, given that OSHA and EPA operate on different timetables. And I think having more informal cooperation is probably going to be of more practical value than a formal referral. The only effort I'm aware of where EPA either did or actively considered a formal referral to OSHA was an effort by OMB to limit EPA's ability to ban asbestos by referring it to OSHA and hoping that their regulation would be weaker than what EPA was contemplating. So that does not strike me as a recipe for effectively protecting people. It's an old example, but it's one that it's one of the few that was used. I would also note that there is an existing MOU on existing chemicals from the 1980s between EPA and OSHA that calls for that kind of informal cooperation before there's any kind of formal referral, so that EPA would give a heads up to OSHA and OSHA would be able to tell EPA in advance whether they're likely to be able to move forward on something before there's a formal referral.
Randy, thank you. Eve, you have your hand up?
Yes, thanks, Jeff. So I think in order for EPA to make a referral under Section 9B, which governs, and here I'll talk about referrals within the agency to another office, that Section 9B, which covers that, requires EPA to be very specific about the nature and extent of the risk that it thinks the other office might be able to eliminate. And I think that's especially tricky for these first 10 chemicals because EPA didn't really do the analysis about exposure and risk related to air and water, which would likely be the other offices that, in theory, that referrals could be made. So I think that's, how EPA might do that for these first 10, I think is a major question mark, because it really hasn't done the analysis that could inform whether or not another agency, another office within the agency could eliminate that risk. And I think the final point is just obviously a referral can't be used by EPA to escape its obligation under TSCA to protect the public from unreasonable risk.
Thank you. Randy, back to you. All of EPA's first 10 risk evaluations identified some risks to workers, unreasonable risks. And for many or most of those substances, it was the workers that faced the greatest risk. So given that we just talked about in terms of referrals and interaction with other agencies, how should the EPA go about then managing these occupational risks?
The first point I'd like to make is that we have a 50-year track record of OSHA regulating health hazards, and absent exceptional circumstances, I think that EPA should follow the template that OSHA has developed over those 50 years. Both ACGIH and NIOSH use similar templates, and that EPA doesn't need to reinvent the wheel. That's the first important point. The second, so that would include setting an exposure limit for any of the chemicals. And it would also include incorporating the hierarchy of controls, by which I mean that principal reliance for meeting the exposure limit should be placed on engineering, process changes, and work practice controls. Employers should be left with the ability to decide for themselves what's the best approach in their workplace, what mix of engineering and work practice controls works best in their workplace. They're likely to be able to find the most cost-effective solution for their processes. Principal reliance on respirators should never be permitted. They are just simply not an effective way to protect workers from exposure to chemicals. I also think that EPA should consider graduated compliance duties so that workplaces with the lowest exposures have the least regulatory burden, and workplaces with the highest exposures have the greatest regulatory burden. And I think that EPA may want to consider how supplemental requirements, in addition to just engineering and work practice controls, can further reduce risks. So some of those that would be important to workers include training, regular exposure monitoring, dermal protections, and housekeeping measures to reduce dusts in particular. And finally, I think while OSHA has always been required to evaluate economic impacts of its regulations, And OSHA uses a test of economic feasibility. The courts have had occasion to define what economic feasibility means. I think EPA ought to look at those definitions, because something that is economically burdensome is not economically infeasible for that reason. So financial burden, all these regulations are going to impose some financial burden, and there should be a much more stringent test beyond just burden for EPA to forego some kind of otherwise important protections for workers.
Thanks, Randy. And if the other panel members just hold for a second, I've got a follow-up question, then I'll open it up for panel discussion on this whole occupational issue. But a follow-up question, Randy, is this. So many of the risk evaluations included in their analysis some assumptions about workers wearing PPE when those risk numbers were identified. Okay, well, given those assumptions that were in the risk evaluation, how do we then use that or deal with that when we now move into the risk management phase for that particular chemical substance?
Well, I thought that was the next question you were going to ask me, but I'm happy to talk about.
No, it is.
Okay.
It's kind of a follow-up. Yes, it's to you, and then I'll open up to the panel.
Okay, so first of all, I think EPA was just dead wrong in assuming PPE use. It's not ever assumed when OSHA takes measurements or analyzes exposures. And OSHA, both OSHA and NIOSH told EPA quite clearly and repeatedly that it was in error and incompatible with established industrial hygiene practice to take PPE into account. EPA ignored those warnings from both OSHA and NIOSH. So I was very heartened to hear Dr. Friedhoff say that EPA was going to change those assumptions. Unfortunately, I think EPA still mischaracterizes OSHA regulations. I think EPA has been very misinformed about what OSHA does and does not require. And OSHA has been clear in Federal Register notices that warnings on a safety data sheet cannot be enforced by OSHA. So even if a company were to recommend specific types of engineering or work practice controls on an SDS, OSHA could not enforce them. They are not required. Secondly, OSHA's respirator standard in the preamble makes clear that a finding of unreasonable risk by EPA does not trigger a respirator requirement. So EPA's conclusion that OSHA might require respirators is just fantasy. In fact, we talked about it at an ABA OSHA meeting, and the management members of the OSHA bar thought the idea was laughable. So I think one thing that's important is for EPA to talk to OSHA and understand clearly what they do and do not require and not to guess. I also think that it's just wrong for EPA to take voluntary measures into account, either in risk assessment or risk management. Voluntary use of PPE in particular is not mandatory. It's not required. You can't count on it across the board. It's bad industrial hygiene policy. It's not a reason to avoid risk management regulations. And it's inconsistent with existing OSHA regulations. And EPA just does not have adequate information to say that any practice is routinely used on a voluntary basis.
Thank you.
I could go on with a half a dozen other reasons why this voluntary stuff should not, but I think I've covered enough. Hopefully nip it in the bud.
Thank you. And I'll open it up for the rest of the panel if other members would like to weigh in on this issue, occupational generally and PPE specifically.
So this is Kimberly, so maybe I'll start here. I know we don't have very much time, but I guess one is that, you know, for several cases in the first 10 chemistries, I think EPA got it wrong in their assumption of the exposure environment for occupational exposure. So they just made incorrect assumptions about the process and how a chemical was being used, how employees were interacting with that chemical. And so they really need to make sure that they're reaching out to the manufacturing and processing environment so there's clear understanding of how a chemical is actually being used at the facility. So I think that's one that it was just not a correct assumption in several cases. And so they need more industrial hygienists to be able to help them understand that process very clearly. I think the other just on PPE use is that you will hear from, from industry, manufacturers and processors that, PPE use is not voluntary within their facilities, that, when staff are participating in a certain job task that is required, that they wear certain PPE in order to perform those job tasks, and training is provided. And then if it's not used for some reason, that's a violation of the process within those facilities. And so it's not a voluntary mandate, it's a requirement for them to do the job tasks associated with those chemistries. And so I think the agency needs to do a better job of surveying the industry so that they have some understanding about how that is actually used in those facilities, the type of standard operating procedures that they have in those facilities. I think there is a lot of concern that the agency hasn't done some outreach to some of those industrial communities to be able to have information and to be able to say, yes, absolutely, we use this. Here's our standard operating procedures at our facilities. Here's how we're implementing this. And here's how we have corrective action if the PPE is not being used at the facility. So, and I guess just the last thing that I'll say here is that I think it is important for the agency to consider personal protective equipment, at least in the realm of being able to understand and put itself in a good position to make informed risk management decisions later on. So to provide that information in some context, so there is understanding about whether or not it's reasonable or not, and then how that will impact its risk management activities moving forward.
This is such an important question that if we need to use our remaining few minutes to talk more about it, then let's just do that. So, and I see that Randy, you'd like to respond or weigh in?
I just wanted to make 2 points, which is when I talk about voluntary use of PPE, I mean use of PPE that's at the discretion of the employer and is not mandated by law. So I understand that some employers, mostly larger employers, may have corporate-wide requirements to use PPE, but I don't think that that's representative of the entire industry or all the places where the workers may encounter the chemicals. And so to avoid risk management based on the fact that some manufacturers of chemicals do have those requirements in place would be inappropriate in my view. It's also true that principal reliance on PPE as a method for complying with occupational safety and health limits has never been permitted. So that would be the first thing. The second thing I want to mention, and this is a smaller point, is in each of the risk evaluations, EPA came up with a category of workers called occupational non-users. And they sort of grouped clerical and supervisory staff with skilled tradespeople. And so based on OSHA's analysis over a period of 50 years, skilled tradespeople are often the people who come in and deal with process upsets or mechanical failures. They may be exposed to peak exposures that are particularly high, but they're very intermittent. And so the way you would look at exposures for that subgroup of people should be very different from the way you look at exposures for office workers or people who may be working 100 feet apart. And I think EPA just missed that subgroup of skilled tradespeople who deal with those kind of process upsets.
Thank you very much, Randy. We're right up at the end of our time. We've got about 1 minute left. And I just want to wrap up by saying that, as you can see from the vigorous discussion that we've had so far, that this is the area of risk management is going to be an important focus area going forward as we move from TSCA 5 to TSCA 6. And it's really going to require all of us to work together, even where we disagree on specific issues, to find a way to make this program work. And as we said, work in a way that gives the American public confidence that the risks are not only being evaluated and understood, but that where they are found, they're being addressed and mitigated according to the law. And our next panel gets into the all-important area of environmental justice, and I don't want to shortchange them even 1 minute. So I'm going to thank the panelists for their excellent comments and turn it back over to ELI to kick off the next panel. Thank you all very much.
Thanks, Jeff.
Thank you all so much.
Thank
We
you.
really appreciate your comments, and I thought this was a fantastic discussion. We will now dive right into panel 3. So I invite our panelists for panel 3 to turn their cameras on. And I have the pleasure of introducing today's moderator, Lynn Bergeson, Managing Partner of Bergeson and Campbell. Lynn has earned an international reputation for her deep and expansive understanding of chemical policy, especially under TSCA. I want to keep this short, but just a reminder that bios are posted on ELI's webpage, www.eli.org. With that, I will hand things over to Lynn. Thank you so much.
Thank you, Chandler. And before I introduce my really extraordinary panel of experts, I just want to thank all of our previous moderators and panelists. This has been just an incredibly rich, wonderful, deep, and provocative discussion of implementation issues. And I really want to call out Bob Sussman for bringing a very diverse group of presenters into the mix. We have much to thank Bob for, and he's worked very hard and wanted everybody to know just how much credit he deserves. We are going to talk now about TSCA and environmental justice, a very important topic. Early in his administration, President Biden announced his goal to reorient all of federal policymaking to prioritize environmental justice. Now, this is an all of government initiative. We've heard much from Administrator Regan on the subject. We've heard an awful lot from Assistant Administrator Dr. Friedoff as well. We're going to be hearing much more. EPA defines environmental justice as follows: the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. Now, defining environmental justice may well be the easy part. Achieving environmental justice is quite another matter. Our panel discussion today is intended to examine the specific role TSCA, the statute, and EPA's implementation of it play in achieving environmental justice. In this regard, TSCA's explicit direction to EPA to consider potentially exposed or susceptible subpopulations, meaning, of course, people who are at greater risk of harm from chemicals because of either greater susceptibility or greater exposure or both, would appear to be uniquely relevant in this context. Joining me in this discussion are 4 incredibly gifted experts in this area. And as Chandler just noted, we have more detailed bios on the conference website, but just very briefly, I'd like to introduce Diane Barton, Council Chair of the National Tribal Toxics Council. This council was created in 2012 with a mission to advance tribal toxics management issues and programs. You might want to review the link to the National Tribal Toxic Council on the website and learn a little bit more about this group. Very, very important. Next, Marian Engelman-Lato, Deputy General Counsel, Environmental Initiatives in EPA's Office of General Counsel. Marianne recently transitioned to EPA OGC. Previously, she served as Director of the Environmental Justice Clinic at Vermont Law School and was also a lecturer at the Yale University School of Public Health and School of the Environment. Next, we have Tim Hardy. Tim is a partner with the Baton Rouge, Louisiana law firm of Brazil.
Zaxi?
Zaxi. I'm sorry, I can't read my own handwriting, which is always a problem. And Wilson. Tim has an extremely distinguished and very diverse career, making him, in my view, uniquely well suited to participate in this panel. He served as a top advisor on environmental affairs for a former Louisiana governor. He also served as Assistant Secretary of the Louisiana Department of Environmental Quality and was Director of the Louisiana Department of Justice. Finally, we have Dr. Adrian Hollis, who is Senior Climate Justice and Health Scientist with the Union of Concerned Scientists. Dr. Hollis, importantly, is also a lawyer, and she has worked for about the last 20 years on environmental justice issues, identifying priority health concerns. Her focus over these past decades has been on environmental justice, equality, equity, and inclusion, and with a view of advancing efforts to environmental, again, I can't read my own handwriting. In any event, Dr. Hollis is quite expert in identifying vulnerable subpopulations and how environmental exposures and other chemical exposures could impact adversely vulnerable communities. Two other words of note, we have added to the materials available as downloads at the website a variety of pre-reads. I think Chandler mentioned that previously, but we have a number of very excellent articles on environmental justice and other topics pertinent to our program today. So please take a look at that. Number two, you may wish to look at the Environmental Law Institute website because there's a wonderful list of recommended articles on environmental justice, and then linger, if you will, on the environmental justice program sponsored by ELI. It's really extraordinary, and there's much to learn there. All right, we're going to follow the same format that the other panels have pursued. I will direct my questions to a lead respondent, a lead panelist, and then open it up for discussion among other of our panelists. The first question goes to Dr. Hollis, and the question is as follows. As EPA places an expanded emphasis on environmental justice across all of its programs, what unique role should it be playing under TSCA? And there are a couple of subparts to this, Dr. Hollis. Do EPA authorities under TSCA provide unique or special opportunities to address chemical risk to environmental justice communities? What are they? And are there limitations on TSCA that constrain how much EPA can do? So Dr. Hollis, what are your thoughts?
Thank you so much, Lynn, and thanks to ELI for the invitation. Very good questions, I should say. And before I answer, I'd like to preface, for those who were here this morning, we heard the assistant administrator talk about some changes and expectations, upcoming changes. And so you'll hear some of my comments relate to those, but even though they've been addressed, but in the spirit of that, I want people to recognize that what role we'll also be playing is that of watchdog to ensure that these things do indeed occur, so that they are still as important and relevant as if she hadn't discussed it. So to answer the first part of your question, which dealt with whether or not EPA, what unique role it should be playing, I want to, and I didn't share this initially, but I'll try to get it to ELI, a wonderful E&E News article that came out in January. A number of the panelists contributed to that article. And what that article talked about was the possibility that TSCA could be used as a way to address and reverse the damage that was done under the last administration, right? Which, as we know, took a deregulatory approach to evaluations and rulemaking. And in addition, EPA has, as the article points out, has the opportunity to utilize TSCA to help this administration, make good on the promises that it has provided for vulnerable populations. And as I said, we've heard some of that today. I think we'll hear some more this afternoon. Most importantly, EPA has the unique opportunity to, in a way, start over, to restore trust and credibility in the organization by carrying out its mandate to protect the public from environmental exposures, incorporating the best available science from both internal and external sources, into its work, and most importantly, incorporating community science and stakeholder input into its decision-making process. It also has the opportunity to work across programs and offices to ensure that those who are disproportionately affected by environmental exposures are protected. Each organization can no longer work in silos. They've got to be, their power has to be utilized together, and we've got to, in that, recognize that compliance with one body of law does not ensure compliance with all of them. And that needs to be an important part of the work that we think that needs to happen. Now, the last thing I wanted to say about this particular question is that the importance of scientific integrity, and of course that's to be expected since I'm at the Union of Concerned Scientists, which has tracked over 990 attacks on science across the government, and 50 of those were from EPA under the last administration. But now EPA has the opportunity and responsibility to address that and put science and scientific integrity back in its work, utilizing both the scientists and scientific knowledge inside the organization and external to the organization. Now, your next question was, does EPA authorities, or do they have provide unique opportunities under TSCA to address chemical risks to EJ communities, and what are they? And the answer to that is absolutely. First, the principles of environmental justice require that communities have the right to participate as equal partners at every level of decision-making, including assessment, planning, implementation, enforcement, and evaluation. The new TSCA, as we're calling it, directs EPA to identify and protect potentially exposed or susceptible subpopulations, and that's at 15 USC section 2006. And it further requires EPA decisions to protect those populations, and to talk about identifying scientific standards that are protected and using scientific information and technical procedures and methods. So EPA has the tools necessary in order to do the work, to examine those who are most susceptible to exposure from chemicals and chemical mixtures. So it's an opportunity and an obligation, really, for EPA to focus on frontline communities, which, as we all know, bear the brunt of exposures from facilities, and up to 80% or more of exposures occur on the frontline communities. And because of this exposure, people become more susceptible, and we've seen that with COVID-19. That previous exposure made them more susceptible more to both infection and death. That's the communities of color in particular. So we've also seen studies, scientific data that has shown a relationship, exposure to particulate matter, for example, and the virus. So indeed, EPA does have a number of unique ways to address these processes. And then finally, you asked about limitations in TSCA. And I want to say that this past administration has pretty much shown us that there are very few constraints, actually. I think the opposite is true, and that EPA can do more, and that because it's really empowered to do more. And for example, and what people have talked about this earlier, the requirement under the new chemical exposure limits in relation to the pre-manufacture notice, or PMN, that substances that present an unreasonable risk of injury to human health via inhalation in this particular scenario, that EPA will issue a TSCA Section 5E consent order, which just requires that workers wear specific respirators. Then further on, EPA has a boilerplate insert that says that there are alternatives to requirements of respirator wear. And so I think that in this instance, this is just an example of where my opinion is that EPA sort of got it backwards, and that the most protective actions would be those that, the first line actions would be those that prevent exposure. And this is part of the precautionary principle that all scientists are aware of. And so I think that a number of the constraints that EPA has identified in the past are mostly, I think, just not thinking outside the box. And but there are some that the fact that TSCA doesn't require pre-market testing for new chemicals, that's a big concern. And I know that the European Union has a program, and someone talked about it, mentioned it this morning in the chat, the REACH program, registration, evaluation, authorization, and restriction of chemicals, where there is a requirement for pre-market testing of chemicals. And so the burden of safety is put on manufacturers. So I think that that is a constraint of EPA currently, and hopefully that'll change. Thank you.
Thank you, Adrian. Great responses. Covered a lot of territory. Do other of our panelists have responses or would like to weigh in? Anybody raising their hand? All right. Well, that was a lot. Thank you. I think it's a wonderful lead into the next question, which I'm going to direct to Professor Engelman-Lado, and that is, what type of outreach efforts is EPA now engaging in to obtain data from the populations most affected by chemical exposures? That's question number one. And question number two is, are these the right kinds of efforts, or should they be done differently or directed elsewhere? What is your response?
Hi, thanks so much, Lynn, and thanks to everyone who organized this. And it's just a delight to see everyone. And I just have to do a shout out to Adrian. And I'm just so excited and honored to be on a panel with all of you. I didn't answer or raise my hand in response to the last question because my remarks really dovetail to some of the comments that Adrian made. I don't have the full answer to your question because we're working on the issue and we're actually doing an assessment of what kind of outreach should be done, and it's a work in progress. Having said that, equity and environmental justice require us not just to obtain data that's relevant to an evaluation of risks to potentially exposed and susceptible subpopulations, but also to make sure we obtain information from people who are most affected, which is the core of your question. But let me start with the part about data that's relevant, the collection of data, and a specific in the toxics area, and on the effort to obtain data relevant to risks and the experiences of population most affected, and then move to Adrian's point that nothing about us without us, that it is a core principle of environmental justice that we have meaningful engagement in all aspects of our work. As I think Dr. Friedhoff said this morning, this month, EPA began to develop a screening level approach for analysis of exposures to fence line communities. And as a starting point, plans to apply the approach for a screening level analysis of methylene chloride, in which OPPT, or the Office of Pollution Prevention and Toxics, intends to include environmental pathways that were previously excluded from the risk evaluation, such as ambient air and drinking water. OPPT is collaborating. We just talked about overcoming silos, collaborating with the Offices of Air and Water, and the development and implementation of this approach will include interagency review. I won't go into the details, and I know it was discussed earlier, but EPA is actively considering whether to revisit or address additional issues as part of the reconsideration process, including whether to conduct additional analyses involving tribal environmental justice communities. And I mention all that because data collection has really these two pieces. We have to make sure at the front end that we're doing the data collection relevant to the questions we want to ask. We have to be asking the right questions. And then, in addition, we have to make sure we're reaching out to the sources of information and recognizing the expertise of communities. Adrian mentioned community science, and that's one piece of the answer to your question about how we obtain data from the population. So more broadly, with leadership from the White House and the administrator, EPA is committed to advancing equity and environmental justice. And as Adrian mentioned, the environmental justice principles, those were drafted at the first People of Color Environmental Leadership Summit and incorporate this principle of meaningful participation, or as I said, nothing about us without us, and also written into Executive Order 12898, both in the 1990s. And both of these say that environmental justice includes both of these concepts. Distributive justice, looking at whether historically disadvantaged communities, including communities of color and low-income communities in particular, are disproportionately impacted by pollution. We need to take that into account in the evaluation. And the issue of procedural justice, that is whether disadvantaged communities have a meaningful say in decisions affecting their future. So this was then reinforced by the president in his first few days in office in EO 13985, Advancing Racial Equity and Support for Underserved Communities. And it requires all federal agencies, including EPA, to conduct a full equity assessment with the requirement that we report back to the White House on an evaluation of barriers to advancing equity and also an assessment in solutions, how we overcome these barriers. This includes all of our programs or activities, including our toxics program. I realize my focus here goes beyond implementation of TSCA alone, but all corners of the agency, including the toxics program, the Office of Research and Development, are engaged in this process of examining both what data and research is most important to address barriers to equity, and also how we deliver on this promise of meaningful engagement and consultation with those who are most affected, workers, fence line communities, susceptible populations. These consultations, of course, aren't new in some ways. EPA has heard from the National Environmental Justice Advisory Council and the BJAC, for example. But in addition, this week, we just kicked off a series of meetings to get input from stakeholders on barriers to advancing equity and environmental justice. And this process will continue, particularly in the fall, as we turn to solutions. And I want to encourage those listening to this panel today to look for announcements and provide input, especially in the fall when we're focusing on solutions for overcoming those barriers to meaningful participation and advancing equity. Finally, I'll just mention that even in our first meetings, we've heard very concrete suggestions that may be familiar to you, such as we have an issue of language access. It is something that EPA has paid attention to. We have a contract to provide language access services. It's critically important that we communicate in languages people speak and understand. Ensuring advance notice for meetings and clear expectations of meeting content. The need for technical assistance to communicate effectively about complex issues. And recognizing that there are trust issues that we inherit from years of experience communities have had, not only with EPA, but with the federal government. Again, none of this is brand new, but we have a commitment by leadership, and there is accountability to the White House to do things better and to strengthen our work on environmental justice and to gather data, to listen to people on these issues. Thank you.
Excellent. Thank you for going into some detail, Marian. I know there are an awful lot of toxics environmental justice initiatives underway, and for a variety of reasons, they sometimes don't bubble up to the top. So it's very important for the TSCA community to appreciate just how many initiatives are underway. Do we have comments or thoughts from any of our other panelists? Diane, please.
Thanks, Lynn. I want to point out also about EPA's commitment to tribal partnership groups like the National Tribal Toxics Council. I think this is an excellent example of EPA's outreach to populations that are affected by chemical exposures, in addition to fulfilling their federal trust responsibility to the nation's tribes. In 2011, I was at a National Congress of American Indians conference and happened to be sitting behind some EPA people who said, why is OPPT putting up this partnership group, the National Tribal Toxics Council? And because tribes aren't interested in TSCA, there's no interest there. But since 2012, we've met with OPPT senior management. We've spent days with TSCA risk assessors and their scientists. We've had EPA leadership out to visit tribal lands, all to better accurately characterize risks that susceptible tribal communities face. Our council since has facilitated an improved consultation with tribes on OPPT issues. We've attended the PFAS Leadership Summit, And we've submitted, as EPA staff here knows, dozens of comment letters, particularly since the reauthorization in 2016. So thank you, EPA.
And thank you, Diane, for emphasizing the partnership between the council and EPA. And again, I urge people to take a look at Diane's bio, because you can link to the mission statement and learn much more about the council. And Diane, actually, the next question I have is directed to you. Some have pointed to the requirement in TSCA, as I did in my opening remarks, to protect potentially exposed or susceptible subpopulations as a very, very potent tool to address environmental justice concerns. What, in your view, must EPA do to apply this requirement effectively? For example, must it in all cases identify every subpopulation at increased risk because of higher exposure or susceptibility and separately calculate greater risks they face?
Thanks for that question, Lynn. And I'm going to add to Dr. Hollis's comments. Our council really takes an aspirational perspective of TSCA's new authority for the protection of susceptible subpopulations. EJ communities do not consider themselves to be statistical outliers, but exposures to these communities must be specifically evaluated and protected through OPPT's risk management evaluation or risk evaluation process. TSCA has always provided the authority for assessment and management of all sources of risk throughout a chemical's life cycle, in the commercial products, in the air, drinking water, waste disposal, fence line living, and the workplace. But because of the addition of protections for susceptible subpopulations, the council believes that TSCA should not be merely thought of as a gap-filling statute, but really should take the role of the nation's primary statute for chemical management. The mere existence of other laws with jurisdictions over particular environmental compartments for a TSCA chemical should not lead to the assumption that those statutes are equally protective of susceptible subpopulations. As an example, the Clean Water Act 2000 methodology for setting human health criteria for water quality standards specifically allows less protective cancer risk levels for highly exposed populations. The susceptible subpopulation language in TSCA is a powerful tool. And to be effective, it's going to require a fundamental shift in risk assessment practices. As Dr. Goldman said this morning, new TSCA really didn't transform the way EPA makes its decisions. Instead, risk evaluations remain focused on general population or central tendency assumptions. EPA really needs to seek out and identify the most susceptible and potentially exposed populations and appropriately evaluate the risks to these communities. For environmental pathways that were discussed in the last session, especially for persistent bioaccumulative toxic chemicals, tribal lifeways that consist of a lifetime of subsistence practices of fishing, hunting, and gathering may represent a sentinel susceptible subpopulation. We note this morning that Dr. Friedoff talked about exposure pathways that are now going to include air and drinking water. These don't at all address the consumption of aquatic biota from game, or much less to aggregate these exposures with worksite and exposure to products in the home. From a health perspective, tribes are also very different than the central tendency populations. They're more likely to suffer from health conditions, more likely to get sick, more likely to have serious complications and die from them. This is these health disparities are well documented, from systemic exposure to social and economic obstacles. In addition, housing disparities contribute to exposure. 40% of on-reservation housing is considered substandard. Outside of Indian country, that's only 6%. Data shows tribal populations are far less likely to purchase furniture or non-durable goods. Why is this important? Older furniture has greater and longer durations of releases of chemical additives like flame retardants in pre-2013 foam cushions, carpets, etc. EPA must consider legacy uses of chemicals in their risk evaluations for EJ communities. And finally, must TSCA identify every subpopulation that's at higher risk and separately calculate the risks? Today, there's 574 sovereign tribal nations, many of which have lifestyles that depend fully or substantially on the local environment for every aspect of their members' lives. Unlike grocery store dependent general populations that don't have place-based cultures, tribal dependence on local foods from particular animals in specific locations can result in higher doses and durations of exposure to localized sources of toxics. This 575 tribe diversity has the potential, though, to provide a wealth of information on local exposure to toxics in the environment. Should EPA identify every population at risk? Probably not, but nor is it reasonable to assume that you have to average desert-dwelling tribal lifeways with those of the Pacific Northwest salmon culture. Instead, a local evaluation of highly exposed fence line or tribal populations will provide more protections for EJ communities and for all people than a single-minded focus on central tendency characteristics and behaviors. Thank you.
Thank you, Diane. Do we have other comments? I think just going into the diversity and the particularity that you did, Diane, helps demonstrate the complexity of the job ahead with regard to identifying susceptible subpopulations and vulnerable fence line communities. The task seems somewhat overwhelming, just given the diversity out there. Any other comments from our other panelists? All right, well then this is a good segue into the next question, which I'm going to direct to you, Tim, and that is, given what we've been talking about and some of the unique features that Dr. Friedhoff indicated earlier this morning, in your view, how well did EPA meet its responsibility in identifying susceptible subpopulations and vulnerable, potentially exposed and susceptible subpopulations in creating the first 10 risk evaluations? And what should EPA be doing differently as it moves forward with undertaking the next 20 risk evaluations? Tim?
First, Lynn, let me thank you so much for allowing me to be a part of such a distinguished panel, and also like to thank ELI. Let me not take up too much time, but let me begin by offering, I'm probably the odd person out on this panel because I've been kind of all over the place, being a regulator, representing industry, being in higher education teaching environment. So let me do a disclaimer on some of my comments because I'm kind of all over the place. Let me get straight to the response. In my view, work has to be done. In fact, work has to be redone on the first 10 risk evaluations. I think it's been pointed out, been made pretty clear that certain intrinsic as well as extrinsic things were not taken into consideration. You can't do a real solid risk evaluation without looking at life stage, without looking at genetics, without looking at disease status or nutrition. And then the extrinsic portions of that, you can't do it without looking at the social and life circumstances, poor communities where there is stress, where there is exposure to other chemicals. And let me just weigh in on one part of this. I agree thoroughly with the concept that you cannot compartmentalize risks. In my view, the utilization of TSCA not only allows, but necessarily should provide for looking at other statutes that allow exposure to individuals and to communities. I don't see how you can do a risk assessment without considering what happens at fence lines, how does the Clean Air Act work with that, looking at RCRA, how is our disposal and our transportation ultimately going from cradle to grave? Is that being done such that we don't create exposure and through certain exposure pathways? Clean Water Act. Of course, we have sources that provide drinking water, surface waters. We have to take a strong look at those and how our water is being handled. And we have situations where we know, even though it's Safe Drinking Water Act and Clean Water Act, there's communication between those two. CERCLA deals directly with impact. When you have a 28.5 and you make the NPL, that's talking about exposure. Those things go into that formula to begin with. So my point is, if those were not considered I think they have to be. Now, let me be clear. I sometimes sympathize with government because when you're first out of the blocks, you learn what you need to know and what you fail to do. So I'm glad there was a process, but that process, in my view, needs to be revisited because now we've able to receive comments, we're able to learn, and before we move to the next evaluations, I think we should revisit those. Aggregating risks is, in my view, very, very necessary. Look, EPA has a really big job, and they have to employ sound science, principles, have appropriate data in terms of identifying, evaluating, and mitigating unreasonable risks. The process, in my view, and this is where I take a hard position, must be understood, must be documented, and we should be able to repeat those results. It's got to be clear. Because one of the things, I'll talk about this a little bit later, is that in almost all of our environmental statutes, state and federal, there's some part that allows discretion by the administrator or by heads of state environmental agencies. I will tell you, courts don't know typically or often how far that discretion goes and what the standard is. So I think it's our responsibility, to the extent we can, to clarify that and create predictability. What should the EPA do moving forward? I think I sort of just answered that. They got to relook at it and incorporate these other things that they failed to incorporate first time around, because there will not be respect from the regulated community, from stakeholders. There will not be confidence in government if we don't fix what we fail to do in with these first 10 risk assessments.
Thank you, Tim. Comments from other panelists? All right. Thank you, Tim. Thank you for drawing upon your very diverse experiential background here as well. This next question is for Marion. We noted in your materials a copy of a November-December 2020 article in the Environmental Law Institute's Environmental Forum. I remember reading it at the time and being just so impressed with it. Marion, in that article, you identify several specific recommendations to, quote, apply civil rights laws to the environmental sector, close quote. You specifically urge an overhaul of federal civil rights enforcement, and among other suggestions, you suggested moving EPA's Civil Rights Enforcement Office into the Office of Enforcement and Compliance Assurance. Do you think this change would advance Congress's objectives in enacting and in implementing Lautenberg?
Well, thank you for the question, and thanks for reading the article. You write articles and they go out into the ether, and you think you're the only person who's ever read the article, so kudos to you. Also, I just want to say, and probably speaking for all the panelists, that there are so many good questions in the chat, and people are raising so many good points. It sort of takes a little bit of constraint not to just jump into all the health impact statements. There are just so many interesting issues that we could talk about. And I also resisted in the last question jumping in about EPA's responsibility in the first 10 risk evaluations, in part because other panels and Mikhail Friedhoff have already talked about ways in which she's addressing and OCSBP is addressing these risk evaluations, including issues like personal protective equipment and other issues. So with that restraint, to answer your question, study after study has shown that people of color in this country are disproportionately exposed to and affected by pollution, including exposure to chemical substances. We can't put our head in the sand and ignore that. As we could discuss advancing the objectives of the Act, we have to pay attention to the actual effects of chemical substances on the ground. And people have been already talking about this, including the cumulative impacts of pollution from multiple pathways of exposure in environmentally overburdened communities where residents face exposure from multiple sources, multiple pathways, and the risks faced by families and workers through the life of chemicals, including at the disposal stage. So I'm sort of reiterating what one of the key run-throughs of this panel. The text of Title VI of the Civil Rights Act of 1964 states, no person in the United States shall on the ground of race, color, or national origin be excluded from participation in, that's the participatory piece, be denied the benefits of or be subject to discrimination under any program or activity receiving federal financial assistance. The law then prohibits exclusion, denial of benefits, and discrimination by any recipient of federal funds, whether they're a state, a local public agency, or a private organization. Like every federal agency's, EPA's regulations pursuant to the Civil Rights Act, Title VI, prohibit actions that are not only intentionally discriminatory, but also actions with an unjustified, disproportionate impact on the basis of race, color, or national origin. Unlike other federal agencies, such as the Department of Transportation or the Department of Education, for example, EPA has historically failed to convey to the recipients of federal funds, states, local governments, recipients in the private sector, failed to convey that the law applies to them. For example, the Department of Transportation makes clear to regional transit agencies receiving DOT funds that they must collect data on race, national color, national origin, the race of transit riders, and evaluate the impact of route changes, just to use but one example. So enforcement of Title VI is an important way to address the disproportionate impacts of chemical exposure on the basis of race. And importantly, implementation of civil rights law and TSCA are complementary. I think Adrian said earlier that compliance with one law is not the same as compliance with all laws. So as we come out of the pandemic, and as we've seen the significant disparities in COVID morbidity and mortality, for example, and research indicating that some of these disparities is associated with exposure to air pollution, as an example, we know we have to act to achieve the goals of equity and environmental justice and ensure we address these racial disparities. Recipients of federal funds in the environmental sector must evaluate, and wherever the external civil rights compliance office is at EPA, it must make clear to recipients of federal funds that they must evaluate whether their actions, policies, and practices have a racially, and I'm using race here to mean race, color, national origin, whether they have a racially disproportionate impact, and whether that impact is justified, whether there are less discriminatory alternatives, and whether disparate impacts can be mitigated. That is what the law requires. So yes, effective enforcement, of course, will further the goals of TSCA.
Thank you, Marion. 2 points. I'm going to use my discretion as moderator here. And Diane, with your indulgence, I'm going to assume that you've already answered the next question that we had in our prepared Q&A, because you gave such an incredibly rich response previously. And I want to move the next question to Tim. But before I do that, I'm circling back to Marion's point about the questions that are coming in from the audience. You know, we could spend an entire day just on EJ. And so cramming this discussion into 45 minutes is challenging, but we are going to make an effort to download these questions and answer them separately after the fact. So don't get grumpy or discouraged. Just recognize we have a limited period of time and we had prepared questions, and I want to move the next one to Tim, because there are a lot of members of the industrial chemical manufacturer, formulator, and distributor community on the line. So I'd like to ask this question. How should industry, Tim, participate in environmental justice analyses? What are the concerns companies should have about environmental justice issues? And how can companies best engage with local communities and EPA? I think this is a vitally important question, and I think you are uniquely well situated to respond to it.
Thank you, Lynn, so much for that question. Pressure. Let me begin by saying I'd like to answer that question in such a way that brings in stakeholders, period, not just the industry. I think it's important for all of us to think that it's not in the best interest of industry, of manufacturers, or potentially impacted communities to allow for ambiguity in rulemakings or in policy. That's not good for any of us. And that's what I run into a lot. Because again, when I'm in court, because the government will get sued, because as was, especially, you remember HISWA, when a lot of requirements were put on the government, the new TSCA puts a lot of requirements on government as well. And when government fails to achieve some of those, there will likely be lawsuits, expenditures by the government, because the government will do what? It will defend itself to the extent it can. So my point is removal of ambiguity. How should industry do this? Well, I think industry has a responsibility to include stakeholders that otherwise might not be able to afford to be at a lot of the tables. You know, industry can afford top technical folks. They can afford lawyers, but communities need to have those same opportunities. So working with community action panels, working with government to provide technical assistance grants to those local communities so they can be at the table with confidence. I think that is so very important. Government needs to help make these available, and industry can inspire government to help to do this. One of the things that I face that I will tell you is somewhat frustrating. And this happened all the way from 1994 to 12898 by President Clinton is, we thought at that time we had something we're going to be able to work with. We thought it was going to be codified. And industry didn't help it become codified. It never happened. So we're operating very often with this whole notion of discretion. I think industry has the capability. It's in their industry, whether we're talking about chemical manufacturers, whether we're talking about people that manufacture other goods that have those chemicals that are subject to TSCA. They need to bring others to the table, and we need to talk. Now, maybe it's pie in the sky for me, but I don't want this to just be a legal exercise and a fight. We've got one planet, we've got one Earth, and having been a scientist when I had a smaller waistline, I will tell you there are few detractors now, or there are few doubters on what we're dealing with in terms of climate change. It's in industry's best interest to prepare, to be able to move into renewables, and to look at risks and look at our populations and think about the costs of healthcare and what this does to our healthcare. Tens of millions. It's going to take $250 billion to even assess and address the Superfund sites we have now. How many more are there? So my only point is industry needs to come to the table, comment, help facilitate communities being at the table as well. Because again, we are at a time in our history where we've seen the convergence of social justice, environment, like we never have before in the history of this country. And that's why it's important for there to be a coming together and a facilitation by industry to help bring others to the table, because they have the muscle to do it.
Couldn't agree more, Tim. Thank you very much. And it breaks my heart to bring this incredibly rich discussion to a close, but we are at 12:32 by my clock, and we're eating into our keynote luncheon address by Bonnie Lautenberg. So I'm going to turn the podium and the microphone back to you, Chandler. And before I do so, my really profound thanks to Marion, Diane, Adrian, and Tim for just splendid remarks. And thank you so much for being here. So Chandler, take it away.
Thank you.
Thank you so much, Lynn. And thank you again to this incredible panel. I thought it was such a good discussion. I will now hand things back over to Lynn Goldman to introduce today's luncheon keynote speaker, Bonnie Lautenberg. Thank you so much, Dr. Goldman, and I will pass things over to you. Thank you so much.
And thank you so much, Chandler. It's my pleasure to introduce our luncheon keynote speaker, the photographer, writer, philanthropist, and businesswoman, Bonnie Lautenberg, spouse of the late Senator Frank R. Lautenberg. In your program on the webpage, there's a very detailed summary of Bonnie's extraordinary life. But to give you a sense of it, her photographs are included in both private and museum collections around the world. Her work, How They Changed Our Lives, Senators as Working People, is now in the Library of Congress here in Washington, D.C., where it can be viewed online. Bonnie is currently working on a book capturing her 25 years of political photography. But on a personal level, I got to know Bonnie as a tireless and effective advocate for the Lautenberg Chemical Safety Act. Bonnie was both Senator Lautenberg's life partner and work partner, and she was a passionate advocate for TSCA reform. In that role, she was sometimes known as the 101st Senator. She was behind the scenes an extremely critical element to the enactment of the law. Many people deserve credit for the enactment of the bill. Legislating is a team sport, but Bonnie, alternatively, was cheerleader. She was policy wonk. She was a committed and valuable team member who tirelessly approached members of Congress to secure bipartisan support for the legislation 5 years ago. And it is fitting that her contributions be honored. This legislation that bears her husband's name and therefore her name as well befits her. She is truly an environmental and public health hero. She's certainly a hero of mine. And it's our great privilege to have her with us today. Welcome, Bonnie. The floor is all yours. Bonnie, we cannot hear you. You may be muted.
Yeah, can you hear me now?
Yes, very well.
Okay, so let me thank you, Lynn. I was just saying, well, you just gave my speech, but I'm so honored to be here, and I thank you really for having me come back again. I was there for the first anniversary, and I'm really pleased to be here now, 5 years later. Let me thank the ELI and the GW Milken Institute and Bergson and Campbell for hosting this event. And I'm totally impressed with the large number of registrants for this conference. It tells me that you are all interested and concerned about the future of TSCA and where we go with this important bill. I am so honored to be on the same program as Mikal Friedhoff. Congratulations, Mikal. I don't know if you're still with us, but you are a brilliant star, and I know you'll be so successful as Assistant Administrator for EPA's Office of Chemical Safety and Pollution Prevention. You've got a huge job ahead of you. After listening to the conference all morning, good luck. Lynn, the panels were so interesting and informative. They were really great. When I read the emails that you sent to Bob Sussman and Lynn Bergeson saying, I accepted your invitation to speak, Bob Sussman wrote back, great, thanks, Lynn. Lynn Bergeson wrote back, fantastic news, thanks. I got that excited when Carol King offered to entertain for free when Frank and I were honored for the SLE Lupus Foundation. Carol King, but fantastic news that Bonnie Lautenberg accepted the invitation to speak today. That put me on edge, because what was I going to say to the 400 brilliant people registered for this conference that you don't already know? I'm not a scientist. I'm an artist and a writer with a passionate voice who had an amazing husband who was a United States Senator and wanted to make a difference in the world we live in. I believed in him and wanted to finish the job he was so damn passionate about. It's now 8 years since Frank passed away and 5 years since we passed TSCA and President Obama signed our TSCA bill. What a great day that was. Especially because it's a very complicated and challenging bill, and we got it passed. Frank always said to me, there's nothing more important than this bill. It's almost more important than the bill he authored to stop smoking on airplanes. It was almost more important than the bill he passed that stopped spousal abusers from getting gun permits, and the 21 age drinking bill. They all saved so many lives, but the TSCA bill was the capstone of Frank's entire Senate career. That's how passionate he was about this bill. Frank's North Star in writing legislation was how it affected the lives of regular people, especially of those who started out life with disadvantages. That concept is written into the Frank Lautenberg Chemical Safety Act. EPA is supposed to ensure chemicals are not endangering people, especially the most vulnerable. If they are making people sick, EPA must stop the harm. The Trump EPA looked at risk from a perspective of big industry. They say factories don't emit enough of this chemical into the air to make people sick, and people working in the factories wear masks, so they're safe enough. And exposures from drinking water don't count, and legacy exposures from companies long ago don't count. But you have to count all the exposures. For the person, the human being that Frank's law meant to protect, you have to count every exposure. That's how we'll keep people safe and keep all polluters accountable. For 3 years after Frank's death, David Vitter and Tom Udell worked on this bill. They worked like crazy dealing with all of you, trying to please everyone in your industry, trying to please every senator, every congressman. It was a 3-year challenge. I asked Tom Udall to work on this bill at Frank's funeral. Can you imagine? I had the temerity to ask him to do that at Frank's funeral. I could not let this bill die. Frank died, but this bill was going to live on, and I was going to help get it passed. Tom Udall was the champion who finally got the bill passed with David Vitter. It was David Vitter who was the Lone Ranger who stepped up to co-sponsor Frank's bill after 7 years of Frank trying to get one Republican to co-sponsor his bill. Frank died 3 weeks later, but he died knowing he finally had a co-sponsor for TSCA. Do you know how it was that David Vitter got to be his co-sponsor? Because David was working on his own bill for 3 years and asked Joe Manchin to co-sponsor his bill. Joe Manchin said, "Oh no, you must work with Frank Lautenberg on his bill, because when we had the 2013 gun vote, Harry Reid needed Frank's vote desperately. And as sick as he was, I took Frank down to Washington and surprised the Senate with his presence. I brought him down there, and when he was brought into the Senate chamber in his wheelchair, his colleagues surrounded him with hugs, so happy to see him. Frank was really sick, and he used every bit of energy left in his weakened body and stood up to say aye for 3 gun amendments they were voting on. One was Joe Manchin's and Pat Toomey's bill on background checks, Frank's on lowering the number of magazines allowed on a gun, and the third was Dianne Feinstein's assault weapons ban. The Democrats lost every vote because of the cowardice in that United States Senate. But because of that day, Frank was able to get a co-sponsor for TSCA. The day they announced that Frank Lautenberg and David Vitter would co-sponsor TSCA, Frank's last day in the United States Senate after 28 years, and the last photo I ever took of him. Having me there was a little bit of Frank too. I was determined to help get it passed, to do what I could and whatever I was asked to do to help do that. I called senators and congressmen to co-sponsor the bill. They all picked up my call. I was blown away by the responses, but all it meant to me was that they had great respect for Frank. Tom Udall invited me to speak at the Environment and Public Works Committee hearing. I was so nervous that when Cory Booker, most glowing introduction one could only dream about, I didn't even thank him. I had never spoken at a hearing before, was so nervous I forgot to thank him. I'm still embarrassed to this day. Tom Udall also had me speak at a press conference outside the Senate swamp for TSCA, when Cory Booker called me the 101st senator, when Senator Tom Carper called me the wind beneath their wings. When things got quiet, and they did from time to time, I would call Tom Udall and ask, how's it going? He always said I encouraged him to keep fighting, even at the lowest times in his battle to get this bill passed. I watched, I saw, I learned what it takes to really get a piece of legislation passed. It's excruciating, and none of you were able to make it any easier. I understand. You all had to protect your industry and the people you represent. It was difficult. I get it. You did your best to help this bill keep on going and still do your job. Do you know the machinations that were going on in the Senate to get this bill passed? Do you know what it was like watching the lawyers work on every word of this bill to satisfy every side, speaking to the chiefs of staffs in so many Senate offices to try to understand the delays, stopping senators in the hallways in the Capitol to get information? We were all doing whatever we could do to keep moving on TSCA. Then, when we were so close to finalizing all the negotiations, 2 senators attached their bill to ours, which delayed it again. Weeks later, when they finally separated the bill, then Chairman Inhofe asked Senator McCain, who had the floor for his own bill, if they could have five minutes for a voice vote on TSCA. Senator Vitt wasn't even there. He had no idea there was going to be this last-minute vote. Jonathan Black, senior policy advisor to Tom Udall and my main advisor all the way through, called me to put on C-SPAN. We're having a voice vote. It passed, yay, but so anticlimactic. I had a big fantasy of being in the family Senate gallery, and I would count each vote. And when it would pass, I would stand up and put my arms in a big V for victory. After it passed, Tom Udall and Jim Inhofe said, "We know Bonnie Lautenberg is watching this on TV from her home in New York." Can you imagine 10 arduous years of work? And all it took was a 1-minute voice vote, and I got an amazing mention on the floor of the United States Senate. No one could have written this script. Some of you were at the dinner we had. For many of the people who worked on this bill, we were 50 people in that hotel ballroom where everyone there got up to speak so passionately about their personal experience working on TSCA. There were so many great stories. Sadly, we never filmed this event, which was such a beautiful and emotional evening celebrating the hard work, and I repeat, the passion so many felt about their personal experience working on TSCA, some for 10 years, and the final success of getting this bill passed. So Donald Trump wins the 2016 election and we're all bereft. Well, not the people who voted for him. I was in Palm Beach, Florida, going to a fundraiser for the Dana-Farber Hospital being held at Donald Trump's home, Mar-a-Lago. We were at this event and David Foster is entertaining. He has pretty women singing with him. Donald Trump walks into this big ballroom on his property. I see he is walking down the aisle and is turning left and would pass the table where I am sitting. I thought to myself, I'm going to get up and talk to him. He's coming. I get up. Mr. President, Bonnie Lautenberg, Frank Lautenberg's wife. Good man, good man. Of course he's a good man. Frank got him the train he desperately needed from New York City to Atlantic City. I said, Mr. President, you must protect the TSCA bill. It's a bipartisan important bill. TSCA, remember TSCA. I sat down, so happy I mentioned TSCA to him. I was crushed when Scott Pruitt stopped funding this bill. Numb. I guess we were all shocked and disappointed, but not surprised. The good news is, with President Biden in office and Michal Friedhoff's influence, we have another opportunity to do whatever we can do to get TSCA back on track and get it implemented. It's so important for our environment, for the health and well-being of all the people in this country, and especially our children and grandchildren. We must get this done. I told Lynn that I wasn't out front during the Trump administration, but I'm excited to be part of any opportunity to weigh in now on TSCA implementation. As I said before, I'm not a scientist, but just another passionate voice who wants to help. Frank's name is on this law. My name, Lautenberg, is on this law. I want it to be strong and effective and protective for all of us, but especially for those who need it most. Those are the people Frank fought for throughout his career. I hope you will all do your part to fulfill the promise of the Frank R. Lautenberg Chemical Safety for the 21st Century Act. Please let me know how I can be helpful, because implementing this bill is so important, and I can't think of anything better than to be honored to work with all of you to get this bill back on track. Now I'd like to toast to TSCA and to all of you. Thank you so much.
Thank you so much, Bonnie Lautenberg. This was such an incredible speech. We just really appreciate your time and willingness to be here. I will turn the floor back over to Lynn.
Okay, thank you.
So, Bonnie, one thing that we didn't think about is whether there might be an opportunity for you to take questions. And I don't know how you would feel about that. We could, simply move into our break, or if you are open to taking questions, we could see if there are any questions.
Well, if there are any questions, let's see if I can answer them. I'm happy to answer if I can.
Certainly. So I'm going to actually ask you, you are working on a book. Could you give us a little bit of a preview about that and whether there's going to be anything about TSCA in that book?
Well, the book is about Frank Lautenberg. It's on Frank. And I'm thrilled that we have a book on Frank. Originally, actually TSCA is in there, of course. And I had originally hired a writer to write the book on Frank's Senate career. And when I read the book, I thought, this is a great book because Frank had an incredible career, but he didn't get to the Senate until he was 58. And he built a Fortune 500 company, ADP, before he went to the Senate. So we had to write about ADP. We had to write about his life even before ADP, because he was a poor kid from Paterson, New Jersey, and he enlisted in the Army and went to Europe and came back and went to Columbia College on the first GI Bill. So after now, and I wrote all the stories about his early life and about ADP, and I kept writing and writing because I spent 2 years up at Columbia in the writing program, and I can write. So then I looked at the book and I thought, this is a great book. I'm the author, but I'm not in it. So then I started writing about my life with Frank, and I've had an extraordinary life with Frank, and the opportunities he had and how much the ability to learn and meet the most interesting people was really fascinating. So I'm excited about the book. Rutgers University is my publisher. Frank's archives are with Rutgers, and Frank would be very happy that Rutgers is publishing this book.
Thank you. As a second question for you, Bonnie, one of the things that I worked on when I was at EPA and really came from a piece of legislation that was authored by Frank Lautenberg was the toxic release inventory. And I have to say that prior to the Lautenberg Act, it was probably the most powerful piece of chemicals legislation that we've had, just in terms of establishing the right to know about chemical releases in communities. It was a tiny piece of APCRA. If you think about the efficiency, the power per numbers of words in bills, we have a lot of pieces of legislation that go on and on and on for pages and accomplish very little. And that provision in just a very few paragraphs accomplished a tremendous amount. And I wonder if you have any insights on that. I can't help but think that that must have come somewhat from the experience in New Jersey and some of the experiences that the senator had with the toxic release.
The story about Frank, he was so conscious about the environment. It really started out when he was a little kid, and his father worked in the silk mills in Paterson, New Jersey. And it was so dirty and so dusty and so noisy. His father brought him into this silk mill and said, Frank, you must never work in a place like this. You must get an education and do something with your life. And so, Frank, it was so poor, the Lautenbergs was so poor that college never even seemed like an option for him. So when he enlisted in the Army and was able to go to Columbia College, it was amazing. But he was always, from the time he was a little boy, aware of his environment and cared about the water and air and everything around him, and was very concerned about what these chemical companies were spewing into the air. So he always talked about making this world a cleaner, better place for our children, our grandchildren, etc. And if you remember when the needles washed up on the beach in New Jersey, he wrote the law to stop allowing boats to dump their chemicals, their garbage into the water. I mean, everything he did was all about the environment and for making this a safer, healthier, and cleaner place, for this world. He was really, very caring and very interested in this subject.
I think I can't help but think that he would have been very happy to hear the discussion earlier and how really all of the panelists have communicated commitment to protection of the exposed workers in particular.
Yes.
That seemed to be a consensus that was emerging from those discussions. People may disagree about exactly the right way to do that, but that is an objective and should be an objective came through clearly and strongly, as well as the discussion about environmental justice, where again, that fundamental commitment to justice and to equity was coming through in these discussions. I think he would have been very happy to hear that.
He would have been thrilled to hear that. And if I were 30 years younger, I'd go and get a PhD and learn all about this because I think it's so fascinating. I just think, oh my God, I'm so impressed with all your panelists and their knowledge, and it was great to listen to it. I'm honored to be on this panel, this program, really.
I don't think I'm the only university that would say, come on, Bonnie, we'll take it. But anyway, I saw Lynn Bergeson appear. Lynn, did you have?
I did. I had a very quick question. And Bonnie, this is the third time I've heard you present. You spoke at our first TSCA birthday party. You just gave brilliant remarks that were so rich with detail. And I heard you speak in the moment right after TSCA was signed into law. You are a brilliant photographer, author, and gifted speaker. I wanted to just throw out a suggestion for your next book, which is your perceptions and your recollections of how TSCA was actually passed into law. Given the hyper-partisan context in which everything is viewed on Capitol Hill today, I'm not sure TSCA could have been implemented today. And the fact that it passed 5 years ago, even to this day, strikes me as nothing short of miraculous. And your insights as to what was going on in real time would be a fascinating read. Just a suggestion.
Well, I will tell you one better, okay? My next project is going to be a documentary film on Frank and on TSCA.
Oh, wonderful.
Okay, and it's got to be, it was such a fascinating, the whole thing is so fascinating that I just think it would make for a wonderful documentary film. And I will be calling all of you and interviewing you and just putting it, getting a film made, because it needs to be for the historic record, what happened for those 10 years and going forward. Even, let's see what happens. It just is amazing to me. They're still talking about the 10 chemicals. All right. Have they discussed anything about the 10 chemicals yet? Are there any new chemicals, or they're still the same 10? I find it so fascinating what they have done so far in these 5 years. Can you help me with that?
Well, we're moving on to 20 more, and laying the foundation for this new law, new risk evaluations has been challenging. So we're making progress, and I think Senator Lautenberg would be somewhat pleased, but probably a little frustrated as well. But we're getting there.
Okay, great.
And thank you for being here, Bonnie. You're just such a wonderful addition to any program. Thank you so much.
Thank you so much. I'm so honored to hear that. I really appreciate it. Thank you for inviting me.
So Bonnie, I placed into the chat box for everybody at the meeting right after being with us this morning, Dr. Friedhoff, and the EPA issued a press release that they have a path forward for their chemical risk evaluations. I think we heard about that path forward in her presentation. I think that was actually a news-making moment. I guess that's probably happened for ELI before, but this is the first time, I think, in one of these TSCA anniversary sessions that we've had that happen. But if you want to go in, all of you, and go into the chat box, you can click on the link and you can see that. And the bottom line is that, as everybody has been discussing, many of the issues that have been raised about the first 10 risk evaluations have led EPA to announce some sweeping changes for how they do those evaluations, which should help to speed things up in the future. And I do think that the approach that was taken, and I think I said this earlier, almost by design, was to move as slowly as possible and to try to preserve the status quo, which is not something that anybody really wanted. There would not have been a bipartisan push to enact this bill, as difficult as it was, if everybody wasn't expecting and hoping for change. And yet we had an administration that seemingly opposed that and moved things forward very slowly, in some cases impeded progress by interpreting the law in a way that didn't require that things be done differently. So you're right to be amazed that we're still with the first 10, but I think the announcement this morning is extremely encouraging.
I'm glad to hear that.
So I'm looking to see if we have any further questions, and I see here now the ELI has come on. I don't see any further questions. I'm thinking maybe we can break for our lunch. And can I turn things back over, Chandler, to you to let people know about that? And thank you again, Bonnie Lottenberg. We've been so honored to have you. Thank you so much. Once again, I feel very inspired by everything that you've done to make this happen.
Thank you.
Thank you so much again. This was just an amazing speech. I really enjoyed this, and I can't wait to read your book and hope to see the documentary soon. I'm knocking on wood on that one. We will now break for approximately the next 45 minutes and reconvene here for panel 4 on new chemical review at 1:45 p.m. Eastern Time. If anyone has any questions during the break, please feel free to reach out to me using the chat function. Thank you all so much, and we will be back here in about 45 minutes. Thank you all.
Oh, I'm so proud of you.
Good afternoon, Daniel and Richard. I just really quickly want to make sure your cameras are working, which both of yours are. Really quickly, I would also just like to test your microphones and make sure those are working as well.
That sound?
Perfect.
How does this sound other than my
Perfect.
voice?
No, it sounds perfect as well. That was really all. If you all want to pop off, you're more than welcome to mute yourself and minimize your camera now. Now that we've got that, we will start back here at 1:45 Eastern. So
Chandler, this is Larry. I'm also on. Are you able to hear
excellent. Me? Yes, I'm able to hear you as well. Larry, you're also now more than welcome to pop off and come back at around 1:45. I'll do a very brief introduction of you, but I think we're in a good spot and all set.
Okay. I plan to save all my popping off or responding to comments made by panelists, but that's a different issue.
Chandler,
anyway,
this is Richard. Can you see and hear me as well?
Yes, I can see and hear you as well. So you're also free to pop off for a few minutes, and we'll just start back here at 1:45.
That's great.
Thanks.
And I guess we're waiting for Alex to weigh in still, Chandler, is that right?
Yes.
Okay. I will. I'll leave your interactions with her without my presence, but if you need, just direct message me. I'm at the computer. Thanks.
Perfect. Thank you so much.
Mm-hmm.